All right, good morning. We have a show cause docket that we're going to run through first. You want me to just quicker if I call them, right? 2001 PR 28, the estate of Susan Ambrose. Mr. Reagan, Mr. Vandervoort.
That is a lawsuit. There's an estate that involves a lawsuit, a medical malpractice case, so that's why it's still pending. We would just ask for another date out.
You want to do it on September 1?
Or that would be fine.
That's 4 months away, but you can do. Oh, 10:30, sorry.
Okay.
Oh, all right. My clerk is telling me I can't do what I want to do, so.
We'll do whatever judge you think is
No,
good.
she's right, because that's a docket call day, and we usually do 9 o'clock circuit civil, and then we do the Chancery docket at 10:30. So we will do, but we don't want to set a bunch of show cause orders, so we'll do it the 2nd of September. How about that? That's usually what I'll do, is I'll reset anything that's not resolved for
Yes, sir.
the next term. So
9/2 at 9.
9/2 at 9.
Thank you, sir.
You're welcome. 2014 PR 69, the estate of Mildred Barkley. Mr. Brown.
Letter from the IRS. They said that a month ago, 60 to 90 days. We could set that on September the 2nd, 9.
September 2nd.
Thank you.
2017 PR 24, the estate of Emmer Dunn. Mr. Odle.
September 2nd as well. I think I'm going to get some paperwork to transfer that vehicle.
Maybe I just need to ask for a show of hands. Everybody who has a case on the show cause docket, all those who want their case moved to September the 2nd, raise your hands. Somehow I knew that would be the response. All right, September 2nd, Mr. Odle. 2017 PR 137, the estate of Okie J. Curley, or Curl. Mr. Massingill.
We're still prosecuting that and working on it, and just raised my hand, so I was wondering if I could get...
September 2nd.
Yes, Your Honor. Thank you.
2018 PR 3, estate of James Cowan. Mr. Massingill.
Yes, Your Honor. I have had no contact with the executrix, and at this point, I believe this came up before, without any action, the court was inclined to dismiss this matter without prejudice for failure to prosecute before. And if the court is so inclined at this time, an order has been prepared to that effect.
All right, so be dismissed for failure to have any activity in it for an extended period of time.
Thank you, Your Honor.
(2018) PR 14, the estate of Joanna L. Sonia. Mr. Odle.
This is the, Judge, this is the case where the outstanding issue is a piece of real estate in Puerto Rico.
Oh, yeah, we're supposed to be going down there to check it out, right?
We are, Judge. My client, last I spoke with him, was going to plan a trip. We've tried to hire counsel from here for that purpose, and but he's going to make a personal trip last I spoke with him.
So what do you want to do, September 2nd?
That would be fine, Judge.
(2019) PR 52, the estate of Jackie Tucker. Mr. Massingill, there's a notice of insolvency.
That's correct, Your Honor. It's been noticed out to the parties, and we've got Ms. Hall here, who I've spoke with, who has expressed no opposition. Mr. Hawley wanted me to relay to the court that he has no opposition. I don't see anyone from the last remaining creditor, but it's clear, the statute's clear on the priority. There's just not enough funds to go around, Your Honor, so I'd ask that the plan of distribution be accepted and that the case be ordered to be closed upon approval of the plan.
We have no objection.
All right, court, you need to prepare an order that shows that there was no objection to the notice of insolvency. The estate is found to be insolvent and will be closed. 2019 PR 83, the estate of Nettie Polinsky. Mr. Brown.
About $2,500 I mistakenly thought that it had been paid in a closing of real estate in December. It will be paid within the next 60 days, so if we can set that, it'll be paid and closed.
September 2nd.
Thank you.
2019 PR 104, the estate of Janet Brown. Mr. Well, September 2nd. 2021 PR 60, the estate of James Grubbs. Mr. Massengill.
That's my case, Your Honor. That is just about ready to be closed. Just a few procedural steps. I just want to double check. I've spoke with Mr. Hawley, and he has no opposition to continue this matter for a little bit more time for me, just to get all the ducks in a row. So I'd ask for September 2nd, Your Honor.
September 2nd.
Thank you, Judge.
2021 PR 66, the estate of Houston Tidwell. Ms. McLeod's case. You heard from them. (2021) PR 78, the estate of Tony Horner. Ms. Franklin.
Both Tony Horner and then one down, Judy Horner. Those are a father or a son and mother's estates. I'm still waiting and trying to settle one investment account. I've got a phone call with the company scheduled for Thursday, so I need September 2nd, please.
September 2nd on both of those, correct? 2021 PR 88, the estate of Mary Throop. Mr. Massengill.
Case and the petition to close and proposed order have been filed with court, Your Honor. It's ready to be closed.
All right, we'll show it's closed.
Thank you, Judge.
2021 PR 181, the estate of Karen Anderson. Mr. Odle.
There was an outstanding issue with an account with some crypto assets in it that was resolved.
Crypto assets.
Some type of, I don't know, what they were trying to deal with it. What I understand, there was an
But I
affidavit.
don't understand what a crypto asset is either, so
Bitcoin, I guess, I don't know, but they.
I don't understand what a Bitcoin is.
But as I understand, Judge, we were at the point of closing and we had gotten everything ready to close. And I think there was an issue with an affidavit of heirship that was done by maybe a Davidson County title company that we're having to fix. So we're going to do that, but it's completely administered and we need to get through that and submit an order
So
closing.
what are you asking me to do?
9/2, I guess,
All
Judge.
right, September 2. 2021 PR 182, the estate of Brenda Brown. That's you again.
Judge, we have gotten all the documents executed with the exception of submitting an order closing. The reason for that is that my client has had some health issues, but there is a storage unit that she put a lot of property that was going to her brother in. He's had some issues and been in some inpatient treatment off and on and just won't come get the property. So we're kind of stuck on that one. She would like for him to come get the property. She's asked for that. I don't know what to tell the court except if we could move it one more time, but it is fully administered with the
September
exception of
2nd.
that.
2022 PR 189, the estate of Annie Biggers. Mr. Odle.
Judge, you appointed me.
Seems to be a pattern here, so.
No, Judge. Judge, you appointed me to be administrator of that estate. At the time, there was believed to be a couple $100,000 at First Bank. I had investigated that, and it was determined that there was a payable on death designee on that account. Since that time, the spouse has passed away, and there's a companion case in this court, a Biggers estate, and there could be a fractional interest in some real estate, and I think Mr. Crutcher's involved in that. I don't know the status of that. I'm not directly involved in it, but this estate was just kind of kept open, so that one, in case it needed to be open for some reason. But the main asset that we thought was out there is not, it's an empty estate. So I guess we'd reset it to 9/2, Judge.
September the 2nd. 2023 PR 34, the estate of Levon Spidal, or Spidal.
We were scheduled, this is a matter, I got appointed as the administrator ad litem. Mr. Oldham's representing the surviving son in this matter. Jay Jackson from Murfreesboro is representing the daughter. The daughter's filed a lawsuit where there was real property that was deeded over. And he's filed a dissolution of a partnership between the decedent and his client, and it was scheduled to go to trial on the 20th and 21st of this month in Wilson County. Mr. Odell and I, we had depositions a couple of weeks ago, and so that matter's now been continued. And we're going to go to mediation trying to resolve that, because then that deals with the ownership of certain personal property. This estate only consists of personal property, farm equipment, things such as that. And so that's disputed in Wilson County. So we have to go up there and deal, Chancellor Smith, I think up there has got that. And so we have to deal with that before we can do this. And then there's a will contest that's been filed that's never been certified. So there's a lot of housekeeping that needs to be done. So if you'll just pass this again, because we do have to wait. There's nothing for us to probate or to do until we get that partnership
All right.
matter resolved in Wilson County. We tried to transfer it down here, but
Realistically, do you think it'll be finished by September?
no, sir.
Then we need to look at January, correct? Am I here in January? I am, right?
Well, I'm hoping maybe I'll be retired by then, but I don't know.
You're hoping to be retired by 2020?
Absolutely.
Let's put it for, since it's just one case, we'll put it on the 4th of January, 2027 at 10:30.
That is, if my son decides not to go to any more advanced schooling. He's set to graduate on Friday with his master's, and so I'm hoping that I'm
His
not
master's is in what?
business administration.
Okay.
And if I can keep our juvenile judge from trying to convince him to go to law school, then
You need a restraining order?
I may need to. It may come to that. It may come to that.
Well, if I can aid you in your retirement by issuing a restraining order, I'm happy to do so, sir. 2023 PR 35, the estate of Bill Carlton, England. No show Sanders, is what you're saying? And last estate is 2024 PR 30, the estate of Marilyn Barker, Mr. Brown.
Vagabond, we can't find her yet, so I'm going to ask you to continue that again and see if we can locate her. September
2nd. All right, we'll move then to the regular docket of show cause of regular cases. 10545-69, it's Story versus Phillips.
For Mr. Knowles on this, my understanding is he hasn't been able to get in touch with his client. He anticipates that he's probably going to end up filing a motion to withdraw if we could reset this one to September 2nd.
September 2nd. 2014 CV 443 in the matter of Christine Scruggs. In the matter of Christine Scruggs. Dismissed for failure to prosecute. 2017 CV 416 in Ray Tiffany Grasty. Mr. Odell. Did we lose Mr. Odell? This is the in Ray Tiffany Grasty.
Judge, that is an unfunded conservatorship that's related to the Emerdine 9-2.
You just want to put an order down? 9-2?
Yes, sir.
Okay. 2021 CV 81, the town of Charlotte versus Clayton Holmes.
I represent, obviously, the town of Charlotte. Judge, we're just trying to work through that. I think 9/2 would
All right,
be
September
the
2nd.
resolution. Thank you.
2023 CV 213 in the matter of James Redden. Mr. Odell again. Somebody. I realize you have a short attention span, but, you know, this is your last one that's on the docket, in the matter of James Redden.
Judge, Mr. Redden is a 10-care recipient. We had sold his house and his car. I have contacted NHC on a couple of occasions. I think 3 times I've gone down there because there were a few items that he needed, like a recliner and a television. We wanted to get approval from 10-care to get those items, not affect his benefits. So that's what we've been trying to do, but it's ready to close.
So you want it on September 2nd?
That'd be fine, Judge. We'll take care of it.
Thank you. Now, that was the last thing I have. You can go back outside and work on your other cases. So. I still believe we need to have a system where it's like a shot collar, that I can have every lawyer have a shot collar, and when it's their case, we can just hit the button. So 20. So that's one of the reasons that I'm a judge and you're not. So, all right. 2023 CV 213 in the matter, I'm sorry, that's the one I just did. 2023 CV 378 in the matter of Ronnie Payne. Anyone here on that matter? Case is dismissed, failure to prosecute. 2023 CV 380 in the matter of Herman Hall. Mr. Brown? You want September 2nd?
Yeah, that's fine. We'll do it in the next 30 days.
These are just the fallback date to try to make sure it doesn't fall in the cracks.
Yes.
2024 CV 65 in the matter of John Kimbley. Anyone here on the matter of John Kimbley? Dismissed for failure to prosecute. 2024 CV 269 In re Emma and Sadie Owens, or Sadie Owens. May I see the file on that one? Are you Lisa Owens?
Yes, sir.
You were appointed as a guardian for your minor children, is that correct? And under the order that went down, the issue of bond was reserved. Ms. Franklin, you were appointed the guardian ad litem in this case. Have you been released?
Yeah, I can't remember.
Well, this states that the requirement of bond was reserved for a later hearing, and this is from September of 2024, that the requirement of bond is reserved for a later hearing. Sidney Franklin, licensed attorney, is appointed as the minor child's guardian ad litem, that the guardian of the minor children's estate shall receive the monies from the sale of the real property, and more particularly Goes on to say that she can execute any documents necessary to effectuate the transfer of the children's interest. That the guardian shall file an annual accounting detailing the financial plan for the benefit of the children, that the guardian shall not make expenditures in excess of $1,000. I think this is one that we're just trying to make sure that everything's been done, and that's why there's a status. There was a December 2024 order that set the bond at $40,000 for each ward. And that the guardian was to file proof of bond with the court and to file property management. So do you want to talk to her, explain? You want the file to look up? So we're just trying to make sure everything's in order. so
Right.
Nobody's saying you've done anything wrong. We're just trying to make sure that everything is done correctly. so. And last on the show cause docket is 2025 CV 148 in the matter of Susie Cobb.
The conservator, Nedra Morris Bailey, the attorney, is on his way from Nashville. He's not here yet. He's en route.
All right, well, that's Mr. Johnson.
Yes, James Johnson.
We'll put it on the second call. When he gets here, we'll try to take it up. All right, thank you. All right, we're ready to call the regular docket.
It's CV 137 in the matter of Eleanor Winfrey.
All right, everybody's going to testify in this case. Raise your right hand and be placed under oath.
Do solemnly swear or affirm.
If you would, please state your full name for the record.
Jordan Taylor Smith.
And if you would, please state your name for the record. Okay, Judge, she wants me to tell you her name. Her name right now is Eleanor Danielle Winfrey. We're going to be changing that today, aren't we? All right. Judge, we effectuated a termination by way of a waiver of interest in this case for the bio. And so based on that fact, we filed a petition for adoption. Jordan Taylor Smith and Mr. James Westcott Smith came to my office in order to get these things accomplished. Is that correct?
Yes.
And everything you've put in your petition is true and correct to the best of your knowledge. Is that correct?
Yes, ma'am.
Okay. And Mr. Smith, you understand that adopting this child today, that you will be responsible financially for her into the future, and you agree to that, okay? And you understand, and I'm gonna steal this from Judge Wolf. He usually says when she comes home late at night, when she's 16 years old, you're gonna have to deal with that. Are you prepared to deal with that?
I'm not sure you can ever be prepared to deal with it, but
And you understand that she'll have all rights of inheritance from you, and you're wanting to do the adoption today. And both of you understand that if anything were to happen to your marriage, in the unlikely event that anything were to happen to marriage, that one or both of you could be responsible for child support for this child. And you agree that you would like Mr. Smith to adopt Eleanor, is that
Yes,
correct?
ma'am.
And she doesn't go by Eleanor. What do you go by? She goes by Ellie, that's right. And are we asking today for your name to be changed, Miss Ellie? Just your last name, right? To Smith? And is that what you want? Judge, I'd ask for you to approve the adoption.
all right, both Mr. Smith and Ms. Smith, you understand that this is going to change the nature of Mr. Smith's relationship with Ellie. And up till now, he's basically a stepfather, but after today, she will be your daughter, the same as Ms. Duke has pointed out. She'll be the same as if she was your biological child. And that means that you will be saddled with all of the responsibilities for this child until the day you die. It doesn't end when she turns 18. When she turns 18, she will still be your child, and you'll still be having to help her out and do whatever is necessary to help her. All right, and you understand everything you're assuming, all the rights and duties and obligations. Ms. Smith, you're the biological parent. Do you agree that this is in your daughter's best interest? I've reviewed the file, and there is a waiver of interest in there, and so based upon that, I don't see there's any need for any additional testimony. Ellie, if I'm going to change your name, I can change it to anything you want me to. Do you want me to change it to Taylor Swift or anything else like that? You sure? You have a beautiful dress on. I have grandchildren who wear those kind of dresses when they're playing Frozen characters. Yeah, that's the way. All right, well, I'm happy to grant your adoption, and I'll sign off on the final decree. So
Thank you, Judge. May we allow for a picture today also?
you may. Y'all want to come up here? Come on up here, Ellie. We'll do it up here. I'll even let you sit in the big chair. You want to sit here? Let your mom sit there. You let your mom sit there, and you can sit in her lap. How about that? And you're relegated to the background. So. All right, there we go. They don't want to deer park in the picture. Hold up. You want to move over here and make room for them? Let's scoot up just a little bit. Everybody. Come on up.
Do you want me to take over?
Let me get something to stand on.
Please? Can you tell me thank you for changing your name?
Here, Ellie, have your own gavel. You know, you can take your own gavel.
Can you tell him thank you?
And we'll give one to your brother when he gets a little older.
Thank you. Thank you.
Congratulations. You want the file?
Ryan Ryder, Gavin.
Good morning.
Good morning.
My understanding that you are wanting to change the name of your minor child, is that correct?
Yes, sir.
You'll raise your right hand and let's place you under oath.
solemnly swear on her.
Yes.
You are Brooklyn Guthrie, is that correct?
Yes, sir.
And you were wanting to change your child's name of Ryder Gavin Guthrie and change it to Denny, last name to Denny, is that correct?
Yes, sir.
And why are you wanting to change his last name?
Because I'm eventually going to go back to my maiden name. Denny is my maiden name.
Okay.
And
Are you wanting to change his name to avoid any sort of court order visitation or
No.
any kind of debts that might be incurred? Are you trying to change his name to avoid any kind of criminal prosecution?
no, sir.
All right. Have you prepared an order to grant that request?
I'm
You
sorry.
have to prepare an order that grants the name change request, and that was what I was asking. You have filed a petition, but you also have to prepare an order. So an order is the document that I sign that actually makes the name change.
Uh-huh.
And do y'all have forms like that? you'll have to go online. You had somewhere that you have downloaded this petition.
Okay.
You can download an order. You don't have to come back into the courtroom, but you can go to the clerk's office and download it, or sign it and file it with the clerk, and then I'll sign it at the appropriate time.
Perfect. Okay.
All right?
Thank you so much.
Okay, thank you.
Ash Green versus
All right. Anyone here on a motion to compel and for attorney's fees? All right, pass it.
IPR 189, the estate of Oil.
Certainly. Second call is what they requested. The next one is the 5th.
2025 CV 137.
Motion to compel mediation, Michael Talley or Thomas Gorham. Motion is stricken for failure to prosecute.
PR 157, the estate of Ray Fuller.
Morning, Your Honor. Aaron Winters of Martin Heller, Patupin Shepherd, Nashville Bar. There are two motions regarding this estate, a motion to withdraw and a motion for fees. Counsel hasn't been able to get in contact with the client for 10 months.
Anyone here in objection to the motion for attorney's fees to be paid out of the estate? All right, no opposition. Your motion to withdraw is granted, and your motion for attorney's fees as well.
Thank you, Your Honor. Have a good morning.
You'll submit an order, is that correct? Yes.
PR 37, the estate of Charles Two.
Morning, Judge.
Good morning.
All right, this is my motion to authorize one of the co-executors to open up the estate bank account. This is Mr. Benjamin Kuhn, one of the two co-executors. He lives here locally. The other co-executor lives in the state of Florida, and it's just really not practical for him to come up to Tennessee to sign to open up the estate bank accounts. We just are asking for the court order to authorize him unilaterally to do
I
that.
think that's an appropriate way to handle it. So since there's no opposition from the co-executor, we'll grant your request.
Thank you, Judge.
Joshua Ingram.
All right, good morning. Let me explain one thing to you. There's a note attached to this form that you have filed that states that someone in this situation owns real property and wanted to file the paperwork anyway under this. So the question is, do either of you own an interest in real property?
We don't have anything together except for the house that she's on the deed for the state of Tennessee. You know, we can't get her off of that until the divorce is granted, everything else.
Well, and therein lies your problem, because if you look at these forms, they clearly state that if you own real property, you cannot use these forms. You cannot use the form for the marital dissolution agreement in particular because it has a specific provision that says neither of you owns real property. It says basically that does either spouse own real property? Real property is houses, land, mobile homes that are permanently attached to the ground, condominiums, or cooperative. You've checked no, but you just told me that you do own some interest in real property. And that is basically submitting a false marital dissolution agreement to the court. Now, where that, what happens in that situation, I understand you're trying to minimize the expense to yourself and so forth, but when you have that situation, let's say that you get your divorce and I approve this, and then she says, no, I'm not signing anything I want my half of the house. And then you say, well, I know it was supposed to be mine. There's nothing in your final decree that mentions the real property. In fact, you have asserted to the court under oath that there is no real property. So you're basically out of luck in that situation. That's why it is said that if you have real property, you cannot use these forms because it requires a more detailed explanation of how the real property is going to be dealt with. For example, a marital dissolution agreement that could be drafted either by you or by a lawyer would state that you're being awarded the real property that was owned by you in your name, and she's waiving any interest in it, and she will execute a quitclaim deed, none of which is in this document. Does that make sense to you?
Yes, sir, and I asked when we came up here to file the papers, anything I needed to do, and I didn't get any assistance from this office.
Well, it's not their job to give legal advice. That's the problem. The clerk's office is prohibited from giving legal advice to people who come in, and that happens all the time, that people ask questions of them. They can't answer those questions. If they had given you some advice and it turned out to be the wrong advice, then who's going to be responsible for that? A lawyer is responsible for his malpractice, his or her malpractice, if they violate, the standards. But the clerk's office are not lawyers. They don't have the job of giving out legal advice. In fact, they are told not to do so. So they couldn't answer that question when you ask them, what else could you do? They did put a note on here that you do own real property, but you want to go ahead and file these paperwork anyway. The only thing I'm telling you is that you need to at least get some sort of legal advice. I'm not dismissing your complaint. I'm leaving the case pending, but advising you that you're going to have to get a more detailed marital dissolution agreement drawn that provides for a real property and how it's going to be dealt with. You understand that? Okay. So what I would suggest to you do, there may be a form online that you can go back to that deals with the real property. Otherwise, you may want to consult an attorney at least on that one issue and get a marital dissolution agreement drawn up. In the long run, the money that you would pay to get that done by a professional would benefit you as opposed to the description that I've given you where down the road, there's all kinds of issues that could arise because you have filed with the court a document indicating there is no real property. All right. Then I'm just going to pass this case on the docket and let you all try to sort that through, okay? Thank you.
Judge, this is my motion as the guardian ad litem, requesting to be discharged and then to approve my fee. Mr. Henry Eugene Myatt passed away in April.
Anybody have any opposition to allow her to withdraw or the payment of her fees? All right, well, I'm well familiar with this case, and I understand that's what's been lacking in it, so
It will be concluded, based on the report, and unless there's some objection coming from somewhere else, Happy Rundle matter's been definitively resolved.
all right.
So again, having the fees and dispersing.
So this is the case where the lady was told that she was a biological heir of,
And his name is on the birth certificate.
and his name's on the birth certificate, and we went through this torturous route to try to get DNA testing, and now the DNA testing has resolved that she is not an heir to the estate. All right. All right. Well, I think there's no dispute about that, then we'll go ahead and make, is there any objection to marking this file
Oh,
today?
Your Honor, got that,
No.
I think probably going on and doing that at this point, so that it's of record before
All right,
Ms. Franklin actually withdraws, so that there's not a date of his heirs coming in.
Ms. Franklin, thank you for your service, and we'll hope that concludes everything in this case.
We'll have to disperse an attorney's fees and all that.
All right.
Not quite yet.
I didn't think I was that lucky, so.
14 CV 126, Dickson County versus delinquent tax.
Good morning.
Tax sale purchaser of certain real property at 2268 Highway 47 East. This is a motion to ask for possession of that property and be reimbursed for certain expenses from the excess proceeds.
Osborne, the county have any objection? Well, the motion will be granted.
I've
We
got a
have an
proposed order, Judge.
Thank you.
Thank you, Judge.
Thank you.
P25 PR 196, the estate of Francis Helen Hanson.
Good morning.
Your Honor, that's our exception to the claim filed by Citibank NA. Not heard from anybody.
What does NA mean? What does it stand for?
It's a
Other than what
initialism that's used in financial institutions. I'd have to look it up. I don't know.
It stands for what?
I don't know. It's an initialism that they use.
I know it's initial, and I've seen it on multiple times. Anybody here know all of those combined legal minds that we have here? Anybody know what the initial NA stands for? I've always thought it just meant not applicable, but you know.
Well, yeah, it'd be interesting to put that with a bank name.
Mr. Region would, I'm sure, know it, but it would take him 30 minutes to explain it, so.
There it is. National
right.
Association.
Do what?
National Association, Mr.
National
Osborne.
Association, Citibank National Association. Anyone here from Citibank National Association to prosecute their claim? No one here, your exception is granted.
Thank you, Judge.
And we've all learned a lesson in the law. It's never too old, Mr. Bates, to learn a few new things, so.
Your Honor, I have an order if I can pass it up. Thank you, Judge.
P25 PR 161, the estate of Helen Hope Clark.
Exception to claim, and the state, TennCare has filed a release, and I'm submitting that to the court.
All right, so that takes care of it, then, correct?
Yes, Your Honor. Thank you.
Just need to mark that. All right, I'll get to him in a minute. We're at John Capps versus One Care Dental Solutions LLC.
Your Honor, these are just two real basic housekeeping motions that I filed. Your Honor will recall, this matter was filed before the court back in July of 2019. And the special master, it was referred to as special master. The special master issued his report in 2023. After that, I filed a motion. There were no exceptions to the claim filed or to the findings and recommendations of the special master. I filed a motion to accept the ruling of the master. Your Honor went through, made a determination that the special master's findings and conclusions of law were correct, and an order was entered. Mr. Bates became involved in the case at that point in time and appealed the matter. The case was referred to the Court of Appeals. They kept it, they rendered their ruling, affirming what Your Honor did, and entered an order stating that you made a determination of and accepted the findings of the master and simply did not rubber stamp it. So what has happened in the meantime, Your Honor, I had filed previously, the court had entered an order for each party to tender payment into the clerk's office for payment of special master's fees. Mr. Bullion, who was appointed as the special master, took an exorbitant amount of time in filing his report, and as a result of that, he waived any fee that he sought. So I had filed a motion to have the court disperse those fees after the order was entered in favor of Mr. Capps. Your Honor ordered that his portion of the fee to be dispersed back to him, but retained Mrs. McGilton's portion of the fee. So we're here asking, just as a judgment, to take that fee and to be applied it toward, to pay that out from the special masters, since he waived his fee, to pay that out to be applied to the judgment that is now final. And we're asking that. And then secondarily, Your Honor, the motion is to approve attorney's fees. At the time that the matter was up on appeal, Your Honor had ordered attorney's fees. I had filed a motion at the time to approve attorney's fees. And we had that argument, and Your Honor found and entered the order that according to section that Tennessee Code annotated that authorized attorney's fees in the partnership issues that we were talking about, that you ordered attorney's fees. I filed an affidavit. The attorney who had represented Mr. Capps at the time is now on the bench in Clarksville, so he had provided the attorney's fees affidavit, and that's been filed with the court. And we just need an order approving those attorney's fees. The Court of Appeals had a footnote in its ruling because Mrs. McGilton had said that she did not think he was entitled to the attorney's fees, but they said Mrs. McGilton asserts that, quote, if appellant prevails on the issues on appeal, the court's ruling regarding attorney's fees will be moot. The issue of attorney's fees is not separately raised, but we have in the event concluded that Mrs. McGilton is not entitled to the relief for the underlying judgment. So we simply need an order approving those after the affidavit was filed approving the attorney's fees.
Mr. Bates, you were kind of, the way I would suggest that what happened in your situation is that it's a drowning man who climbed aboard the Titanic right at the end. So I understand that you got in late and things had already pretty much been resolved, but do you have anything you want to say about this?
No, Your Honor, the court has discretion to enter the order.
I think it's pretty clear this is both of these motions must be granted, so I will grant your motion. So.
And Mr. Bates was just hoping that you didn't refer to the ruling where he said you simply rubber stamped the special master and did not make an independent
I've
finding.
looked up here, since I read your argument, I looked up here to see where the rubber stamp was that I supposedly used, but I don't find it anywhere.
Word of my day is remunerate, and I failed to remunerate today after my previous arguments in the brief that were rejected.
I
And
understand.
rejected quite eloquently by the Court of Appeals, I might say.
It's nice to see the court.
You're welcome.
2024 CB 199, Adam Smith versus Charity Smith.
Put on the second call.
Thank you, Your Honor.
2025 CB 119, Edlet versus Morgan.
There's a motion to compel discovery. Is that a moot issue? All right. Let me see what else I have then.
2026 CB Jill Smith versus Walter Smith.
All right.
Next on the docket, it had been removed, but those folks that entered
That was the Jones versus Jones. Okay. Mr. Vanderbilt, I'm going to have to give you the gold star today. You've taken care of quite a few cases. So.
Jenkins versus Stephen Chancery.
If we could maybe pass that, and let me speak to Mr. Taylor to see if we can resolve
Right.
those, or.
I'll take a recess in a minute before we start your contested case and give you an opportunity to resolve anything you can.
Yes, Your Honor.
All right.
2023 CD 103, Bennett Marcello versus
Is on that.
Yeah, I just got notice, Saturday morning about this, so.
All right. Are you, when you say you're contesting it, are you wishing, you said that you just got notice Saturday morning, are you wanting time to hire a lawyer?
No, I'm representing myself.
You're going to represent yourself? Okay. All right, well, you're last on the docket, so we'll get to you as quickly as we can, but we have a contested case that I'm told is going to take most of the day. So understand that's the next time that I'm holding Chancery Court. If we don't get through anything today, the next days are the 18th and 19th and the 26th. Are we still, Ms. Roberts left on the, you're not involved in the Marlin case, are you? Mr. Potter is, I think. Is that correct? He's not any longer. Anyway, so whatever we don't get to today, by the close of business, will be rolled over to one of those 3 days that we have the rest of the month.
Would that be this month because?
It's this month. The 18th, 19th of May, or the 26th of May are the 3 days that I have remaining in Chancery Court here in Dickson. The rest of it all criminal, so.
Judge, so you're aware what when we're taking this up, this is a relocation case where the father relocated to Florida without permission of the court.
I read
So-
through the file. So.
Perfect.
All right.
Thank you, Judge.
All right, we're going to take a 15-minute recess to allow the, Ms. Franklin, you have something?
Announce that before you take your
Which one is
recess.
that?
It is on the estate of Roy Overton.
Okay.
I had filed a motion to compel an inventory. Mr. Osborne did provide an inventory and some bank statements. I think we've agreed that he's going to have 14 days and do a supplemental. He'd provided the decedent's estate, the decedent's account statements, and we just want the estate statements.
All right. Then that'll take, you're going to do an agreed order.
Yes.
All right. And I failed it. Mr. Johnson, you want to take up your show cause matter, which was in the matter of Susie Cobb? Good morning.
James Johnson, I received notice, I thought it was for a status review, and so I have a copy of the inventory and the property management plan that I'd like to submit to the court for review. And there was no bond set, so I'll go through each one of those items with the court rather quickly. It shouldn't take long.
Okay.
As you can see, Your Honor, from the real property, the real property was valued at, when the conservatorship was established, the conservator, the ward owned a house worth $231,000. Judge Marsh approved the sale of that property. That property sold for $180,000 or in that neighborhood, I believe it was, Your Honor. She also approved the disbursement of the expenses incurred in the sale of that property. And now there's an order in the file where she approved of those disbursements in the sale of that property. That real estate no longer exists, Your Honor. So in the bank, after all the expenses have been paid, there's a balance of $130,697. So that along with her monthly income, Your Honor, she gets monthly income of $2,243. Social Security and a pension. So the court, there's never been a bond set on this, and so I would like for the court to go ahead and tell us what bond amount should be established or be set on this, and we'll get that bond in place.
Well, I don't want to burden the estate with an excessive bond, but you're saying that there's $130,000 roughly?
In the bank, $130,000 in the bank account, Your Honor.
I mean, I would say that would be the amount of the bond.
Okay.
And not worry about the monthly income, but the amount of actual liquid cash assets would be the amount that we need to. So let's
Okay.
set the bond at $130,000.
$130,000. I can get on that this week.
Okay.
Okay, and there are no debts, again, Your Honor, and she has monthly expenses that total over $5,000, so that 130 will be going. She's in an assisted living facility, so most of that 130 over the rest of her life will be going to pay for that.
Well, I think that complies with our status requirement, so I don't see there's any real need for us to, normally what we do is in a year or so, we'd send out another, show cause just to see what the status of it is.
Yes.
Sometimes people pass away and they don't, on these conservatorships, and they don't let us know, and we've got a file that remains open, so
Yes.
it'll probably just be set for, let's just set it in January, on that January the 2nd day for just a status to see how she's doing.
Okay, and we will do and we will submit an accounting before
All
that,
right.
so the court will have.
Do an accounting, and by that time, you should be able to get your bonds, so.
Will do.
All right, thank
Okay,
you.
thank you, Your Honor.
Mr. Odle, would you, something else, anybody have anything they need to take up before I take the recess?
Judge, we had the motion to set on the Green case.
Chaz,
Mr. Odle
Chaz
went on
Allen
it.
Green versus Julianne Nicole Green.
Yes, and the court provided me with August the 26th, August the 28th, September the 2nd, and September the 21st. They gave me one more date, but that date was not available on my calendar, so I was just waiting Mr. Odle to tell me what he's available.
Now, August is a different judge. I'm here in September, but August would be Judge Turnbow.
It really
Doesn't matter to me.
does not matter on this one. Nobody's heard anything. He's been in jail. September the 2nd works, Judge.
All right, September 2nd.
Mainly the issue will be visitation with the kiddos, so 3 hours, 4 hours? Half a day.
Half day.
On the Jenkins versus Taylor matter. Your Honor, Mr. Taylor had reached out to Mr. Vandervoort, but they represented my client in some estate planning scenarios. So we have got some various motions. We're going to strike our request for possession of the marital residence, and Mr. Taylor's going to be, stay at the marital residence and pay the mortgage and the debts associated with the marital residence. Mrs. Jenkins is going to be able to coordinate with him, and she and a friend will be able to come over and to pick up her uniquely personal items from the marital residence. And then we're going to pass anything to give him time to retain counsel.
All right. Mr. Taylor, you understand what's being agreed to today? All right. And we'll show that the matter is you're going to submit an agreed order on that one issue,
Yes, Your
and
Honor.
then the rest of the issues will be reserved.
Yes, Your Honor.
All right.
Thank you, Your Honor.
Anybody else have anything that you want to announce before I take my recess? All right, we'll stand in recess for 15 minutes. When I come back, we'll be taking up the first contested case, which is the one that Ms. Roberts indicated was going to take the rest of the day, and that is Lori Neblett versus Morgan Shea Moorhead et al. All right. You can be seated. Well, it is stricken. So. I, I don't think it's our place to call somebody when they have a case on the docket. Striking their motion to compel and for attorney's fees. So if they want to undo that, then they can file the appropriate motion. All right, then you're ready for the Neblet. What's, well, this was set at 9 o'clock.
I put them in order on there because that's how they have to happen.
Because it had 10:35.
All right.
No, I didn't say, what have you done?
What?
What we're trying to do.
This is on Smith versus Smith. Okay. I thought it was the final. I'm aware of that. So. All right, so on Adam J. Smith and Charity Lynn Wheaton Smith, you want to move that to? On which? So on the Morcillo cases for hearing, correct? Well, you're last on the docket, so. All right, Lori Neblett, Morgan, I'm sorry, Lori Neblett versus Morgan Shea Moorhead et al. This is a petition to establish grandparent visitation, correct? Resolved, okay. Then we are ready, and the rule has been requested, so anyone who's going to be a witness other than the parties must go outside of the courtroom and remain outside of the courtroom until you're called to testify yourself, and you're not to discuss the testimony of any other witness pending your own testimony. Is that monitor out in the TV out there is not on, is it? All right, thank you. All right, anybody, either side wish to make an opening statement?
Your Honor, when my client came to me, I explained to Ms. Neblett the difference between parental visitation and grandparent visitation. I explained to her that the hurdles that we have that are given to us in 366306 are very specific, that we must show, first off, that my client was blocked from seeing her granddaughter, and secondly, that she did have a significant relationship with her granddaughter, and you will see in the testimony today that that was true at the beginning of the granddaughter's life, and then it was sporadic throughout the rest of the granddaughter's life, depending upon whether the father would allow it or not. Thirdly, we must show, and I explained to her, that having no visitation at this point would put the daughter in danger of substantial harm. So you'll hear testimony today that that was a significant relationship, not only testimony from the grandmother, but also from those who were in observation. And then finally, I explained to her that the court must determine if it's in the best interest of the grandchild to have that visitation with her grandmother. So I told her that this is certainly not a done deal. She said that she wants her Oakland to know that she did everything that she possibly could to see her, to be with her, and to love her. And that the only reason that they couldn't be together during this period of time was that the father wouldn't allow it. So with this hearing on the record, she can at least demonstrate to the granddaughter, even if she doesn't prevail down the road, that she tried her best to get with her.
Robert, you wish to make an opening statement?
Principles that a parent has is to raise their children in the manner that they see fit. And it is and in order to infringe on my client's constitutional rights to raise it, there's a high burden that the grandmother has to prove in this case. Again, Your Honor, I have filed with the court some admissions that I filed a request for admissions. I have filed those with the court, and I would ask those to be deemed, right now, before the onset, for those to be deemed admitted.
All right, no objection, then any requests for admission that have not been answered are now deemed to be admitted.
And then at an onset in getting into it is, you will recall this matter was first filed by Mrs. Neblett, where she only sued my client, Mr. Donald Colt Riddle, the biological and the primary residential parent of the minor child. I filed a motion in that to dismiss, and I actually filed Rule 11 sanctions. Had to come before the court to get that dismissed. Had to proceed in the court to get that done. The court granted leave. It was dismissed, and then it was refiled, wherein Mrs. Lori Neblett, the maternal grandmother of the minor child, sued both Morgan Shea Moorhead and Donald Colt Riddle for grandparent visitation. To my knowledge, Morgan Shea Moorhead has failed to file a response
That's correct, Your Honor.
and is not present.
Correct.
So I want that of the record, that the mother is not here. Has been duly served now on the second petition,
All right.
but has failed to appear. I don't know how notice was provided to her of the hearing, but I do want to clear it up and to make sure that she was provided notice of this hearing. And so I would, again, if counsel would address that how he certified.
She was served at the very beginning with the petition, and she never responded in any way whatsoever.
And that is exactly correct. She didn't respond, but there's been no motion filed for a default, and there's no notice to her. Again, there was a motion to set that was filed.
Right.
And so I just want it clear so that we're not coming back and saying that.
Well, there was an order entered on March 16th that states the following. This matter came on for hearing on the second day of February 2026 with the Honorable Larry J. Wallace presiding on the petitioner's motion to set. It appearing to the court that counsel for the petitioner, Lori Neblett, and respondent, Donald Colt Riddle, agreed to set the matter for hearing on May 12th, 2026. The respondent, Morgan Shea Moorhead, having been provided notice of the hearing, failed to appear. It is therefore ordered to judge and decree that this matter shall come on for final hearing on the 12th day of May 2026. And then there was a certificate of service that you had served on Morgan Moorhead, a copy of that on the 9th day of February.
Again, this is the maternal grandmother's daughter. So again, I just want the record clear that there's nothing, and again, not alleging that there's any subterfuge or anything. I just want the record clear that.
Record is clear that she has been given notice, she was served, and she's been given notice, and that there's no problem as far as this court is concerned, just because there was not a default judgment. She's not present, so we'll proceed without her.
Right. I just, again, wanted to make sure that the record was clear to that.
All right.
And again, on those admissions, Your Honor, again, Your Honor's well-versed, I'm sure, in the statute on the grandparent visitation rights. The parties are divorced, so that gives rise to the permission to file. But again, the standard is that that Mrs. Neblett in this matter must prove severe emotional damage or the threat thereof to this child in order to infringe on my client's constitutional rights. There's no presumption raised based on the admissions that have been filed that there is a significant relationship. So again, the significant relationship has to be proven, and then that the severance of that significant relationship will cause severe emotional trauma to the child.
All right. Mr. Mize, you may call your first witness.
Yes, Your Honor, I'd like to call Lori Neblett.
Ms. Nebel, if you'll come around, please. Counsel, let me see you, if I may.
Oh, okay.
Let me just ask you. Ms. Neblett,
Yes, sir.
you look very familiar to me. Have I ever had any contact with you as far as representing you or having, when I was a lawyer, having any contact with you in any direct
No, sir.
situation? Okay. My job is to try to be as fair and impartial to everyone that comes before me. And when I see someone, and in my age, you know, things kind of run together, but I had 37 years of practicing law, and for a result of that, there are a lot of people that look familiar that I'm thinking I may have represented.
May I say, I drive a bus and my route is through Charlotte, so.
And that wouldn't be it, so, okay. All right, thank you. I just wanted to make it clear to both sides that there's no issue, so. Thank you. You know, go ahead, Mr. Mize.
Thank you, Your Honor. Could you please state the name, record?
My name?
Yes.
Lori Neblett.
And Lori, what is your relationship to Oakland?
I am her grandmother.
Let's start out a little bit about your passion for children and a little bit of your background to let the court know. Explain to the court your involvement in summer camps and what they were.
How is it relevant, Mr. Mize, to the statutory requirements?
Well, we want to show that there not only was a significant relationship to the grandchild herself, but that Ms. Neblett is certainly appropriate to have that type of visitation because she's been around children her whole life and in many different ways.
Well, I'm going to overrule the objection and just allow a very limited inquiry into that aspect because as both sides have made mention of, the statutory requirements are very strict and very precise, and I must adhere to those whether I agree with them or not. So as a result of that, I'm going to allow you to give this background, but let's make it limited, please.
Thank you, Your Honor. We'll skip the summer camps for right now. Just explain to the court kind of the history of your employment. For example, were you ever with the school system?
Yes, I was I worked at the Dickson County High School for 15 years in special education, and this is my 20th year to drive a school bus. And I also served as an RBT, which is a registered behavioral technician through a company called No Boundaries.
Thank you. And you're still driving a school bus now, right?
Yes, this is my 20th year.
During this whole time with the school system, because of course, one of the aspects of determining is best interest for the child. So we want to be sure to show the court that you are not a danger to the child in any way. So in your...
Mr. Mize, you are testifying rather than asking questions, so sustain the objection. Don't
Thank
leave
you,
the
Your
room.
Honor. Have you ever been disciplined in any of your positions for any kind of inappropriate behavior?
No, sir.
All right, let's cover a little bit of the history in dealing with your relationship with Oakland. So let's kind of begin at the beginning.
Okay.
When was Oakland born?
Oakland was born September the 25th. I was actually there in the room when she was born. I was on one side, Colt was on the other side.
You were present at the birth.
Yes, absolutely.
And we have submitted in our discovery several early on. I'm going to show you a photograph here.
Oh, yeah.
I'm sorry.
I'm sorry.
That out right now.
It's okay.
Yes, that's a good idea.
I have them on my phone.
That'd be great. Yes, thank you.
Our matter,
All right, that's the Smith case. All
I
right,
didn't want them to have to sit here.
I don't blame you. Adam J. Smith versus Charity Lynn Wheaton Smith then will be reset for the 29th, and then whatever agreement you've made on the interim will. All right. All right.
So, Ms. Neblett, you've been handed several photos. If you'll look through those photographs for a moment.
This is what I call my sweet baby O. This is my sweet baby O.
So in all of those photos is open, correct?
Yes.
And about what age would that have been?
Well, it looks like this one, I was giving her a bath. We call it a sink bath. So I was giving her a bath in the sink at the house. Probably maybe 6 months, 7 months old at that time. This is Poppy, my husband. This is her, him holding her. This is another one when she was a baby. This was when she was older, maybe a year and a half, 2 years old. This was, I think we were at a restaurant. We would go eat Mexican. This was at the house. And this, I'm not sure where it was, but it might have been at a Mexican restaurant. I don't know. We would go out to eat. Yeah.
Your Honor, if I could submit them all.
All right, we'll mark them as a collective exhibit 1. Did you had filed your request for admissions, Ms. Roberts, and made mention of the fact they're in the court file. Or were you asking that they be made an exhibit? All right, which we've already established. All right, thank you.
So does that mean the photos are already in?
The photos are exhibit 1, now admitted. So
All photos that were in the discovery? Oh, okay.
just the ones that you have
Okay,
shown her.
thank you. I appreciate that. All right. I got you. Okay. All right, so during that first 2.5 years of Oakland's life, could you explain to the court how much you were a part of Oakland's life and what type of activities and how often, that type of thing?
Absolutely. During the first 2.5 years of her life, I was very much a part of her life. I would drive to Nashville. They would come to Dickson. We would go out to eat. All of us together, Colt, his mom, his brother, we would all celebrate birthday parties together. I know one, I think it was Mother's Day, we went, me and Colt and Anthony and his mom and the girls, Oakland and Oakland's older sister Willow at the time. We went to Old Charlie's and enjoyed a Mother's Day brunch. It was just like normal, normal family time that we would spend together.
And about how often? Weekly?
Yeah, I would say weekly, for sure. Like I said, I would go up there. This is when they were living in Nashville. They hadn't moved to Dickson yet. And so I would work all day at school and then I would do my bus route. And then, if they weren't at the house when I got there, then I would get in the car and I would head to Nashville.
Just I'm going to show you one other picture. I think this is when you were
Oakland.
If you could explain to the court what that picture is.
Yes, this was, there was an Easter egg hunt. There was an Easter egg hunt in Nashville, and we had, or maybe this was the zoo. This was the zoo, but I think maybe it was the Easter egg hunt also. We all went as a family. I went, to help them with the kids. So this is Morgan, Colt, Willow is actually on Colt's shoulders, and Morgan, my daughter, is holding Oakland, and I took the picture. So,
Thank you. Could we have this?
yes. Mhm.
So is it fair to say that at least during those first 2.5 years, you were basically a part of the family? Is that correct?
100%.
And then explain, around 2016, if you could explain what happened at that point.
Things started getting rocky, as I recall. When I say rocky, Colt's and Morgan's relationship was starting to go bad, and they were
I'm
like.
going to interrupt you just a second until the court understands. And who is Morgan?
Morgan is my daughter, Oakland's mother.
Okay, go ahead.
Their relationship started to get rocky, and Morgan was, I feel like it's been so, Morgan was doing her thing kind of, so I was seeing Oakland, I was driving to Nashville at least once a week, and I was asking Colt, when is a good time for me to come up there? I want to see Oakland, and I would go up there at least once a week. And even a lot of times his mom was there with Oakland, and I would even get on the phone and I would say, I would bring them all something to eat, and we would go spend time.
Yes, and I have explained to my client that she cannot give statements of what other people said outside of this courtroom, certainly whatever Colt has said to her, but I think you understand that, so.
I do.
All right, Ms. Roberts has withdrawn her objection after that clarification, so.
So, I think you were talking about during this breakup, you continue to still try and attempt, or you did seek Oakland?
With
Sustained, don't lead the witness, please.
Go ahead.
Okay, so I absolutely tried my darndest to see Oakland. I would call, I would text. So finally, it got to the point where he would not answer my text anymore. He would not correspond whatsoever. I didn't go up there unannounced. I always wanted to make sure that, he was going to be there, but he cut off all correspondence. And from then on, it just, I couldn't see her.
At what point did Colt reach out to you again?
This was probably 3 years later. They had moved to Dickson in Charlotte, and Willow and I, Willow is Oakland's older half-sister. Willow and I were at Jonah's Pizza, and we turned around and we saw Oakland with Colt's mom, and Willow and I looked at each other and our eyes got real big, and we thought, oh my gosh, this is. Okay, so.
We'll let her limit her testimony as to what my understanding was she was thinking this, oh my gosh, this is what she thought. So I'll accept it as, can't testify what someone else thought. But
I'm
you can.
sorry, I'm sorry.
You can testify what you thought.
Yeah, I looked at Oakland and I was like, oh my gosh, this is Oakland. I haven't seen her in so long. I mean, I was ecstatic. And of course, after not seeing my granddaughter for 3 years, I just rushed to her. I just wanted to hold her. And I know this sounds crazy, but I just wanted to smell of her. I just wanted to smell of her head. I just wanted to breathe her in, I guess. And at that point, Colt's mom gathered their things before Oakland had even had a chance to finish eating, and they left. So it was shortly after that Colt had reached out after he and Allie Kate broke up. He reached out to me and said that he wanted to have Oakland come to family events and that kind of thing and be a part of, the family, and for things to be, like they should be. I was ecstatic.
And during this period of time when you were able to maintain or get back to some contact, for how long did that go on, and when did that stop?
She was approximately 6 until about 9, I was able to see her when Colt said that, we could see her. I could see her. I would meet at the CB store in Charlotte, and I would get Oakland, whenever he would allow that. So that lasted for about a year, and then Oakland got really into ball. And so they were doing a lot of going to, ball games and ball practice and that kind of thing. So in order to see Oakland, I had to see her at the ballpark. And so I would go to the ballpark, Willow and I would go see her play, that kind of thing. She was doing travel ball too, so I would even go to places, far, wherever they were playing. And I was able to see her at that time, like through the dugout. It wasn't quality time, but at least I got to see her.
During that time that you got to see her, did she get to see you as well? I mean,
Yeah. I mean, we would, she would come to the dugout fence or whatever, and we would have a drink, and me or Willow would stick the little straw through the dugout cage so that she could get a sip and, wave hi, and I would, try to get a picture.
did you attempt during that period of time to see if you could get some other kind of visitation other than just at the ballpark?
I would always text and say, or call, I would even call her on the phone, and I was able to call her too. But I would always text and say, I would love some quality time with Oakland. I want us to go and get our nails done. I want me and her sister to go, have a pedicure, go out to eat, go shopping, that kind of thing. But it was always kind of shut down. They were always too busy.
And then did there come a time when you were shut off completely? Explain to the court if anything happened down the road when that all stopped again.
So what happened was when I wasn't able to see Oakland for just at the ball games or whatever, me being a bus driver, at the end of the year in May, they always call it that's the field trip time of the year. And so Oakland's class was going to go to the Adventure Science Museum in Nashville. So I jumped on the opportunity to drive for the field trip. So me and another bus driver, we got there at Charlotte Elementary, and I was parked around back, and I was waiting for the classes to come out. And so Kristen, who was Colt's wife at the time, she had gone in the building, and I wasn't quite sure why she was there. Next thing I know, the kids start to come out of the schoolhouse and to go get on the bus, and Kristen got in the middle of the parking lot and raised her hand up in front of the classes and the children and said, "Objection, hearsay." Oh,
Your
I'm
Honor,
sorry.
that's fine, because we're going to have Kristen testify to this. Let me just ask you
I'm
this.
sorry.
No, that's okay.
I was just telling
You're
my.
doing great.
I'll sustain the objection, but I would remind you that hearsay is a statement made outside of the courtroom being introduced to prove the truth of what is said in that statement. So not every statement made outside of the courtroom is hearsay if it's not being offered to prove the truth of the matter. But since you have the witness here, let's move on.
Thank you, Your Honor. Let me just ask you this, without saying or stating what was said. Were you prevented from, were you,
Overruled.
was there any indication that there was a no contact now between you and the child?
Yes. I was told that I was put on.
Did the school resource officer prevent you
When there
from
is an
seeing?
objection, let me rule on the
Oh, I'm
objection.
sorry, Your Honor.
Sustain the objection.
Did the school resource officer prevent you? I haven't even finished my question yet, Your Honor.
Let him finish the question.
Were you prevented by the school resource officer from seeing Oakland?
Yes.
I'm going to overrule the objection to that particular question.
Thank you, Your Honor.
Can I say it was just at that time?
It's fine. You've done well. You've set it up. When was this? Do you remember the date?
It was May of 2023 or it was May. I think she was 9. So May of 2024, maybe.
Is that when,
or
by the way?
23, I can't.
Yeah, that's all right. In the record, there are a few nasty text messages from you. I think something about referring to the father as a fucking child abuser.
I did.
When did that happen and why did that happen?
Well, after, that happened after I realized that I was on a no contact list. I had never known this up until that date. And I had never responded in anger Oakland's entire life until that day. And that's when I responded in anger. I think at that point, I was emotionally torn apart and distraught, and I did text in anger. I did.
Why did you take this legal action?
I took this legal action because, well, I mean, I want to be a part of my granddaughter's life. I want her to know her Omi. I want her to know her Poppy. I want her to know her family. I want her to be able to see her sister, Willow. In my mind, I think the best thing ever would be me and her and Willow cuddling up on the couch and watching a movie together. I want to be a grandmother, and I want her to know that her Omi loves her with all of her heart.
Explain
And
to the court, who is Willow?
Willow is one of Oakland's sisters. Willow is Oakland's sister,
And who is the father of Willow?
Daryl Miller.
And your daughter is the mother, correct?
Yes.
Do you know where is Willow now? Who has custody of Willow?
Daryl, her dad. Primarily.
Do you have visitation with Willow?
Oh my goodness, Willow has her own room at our house. I see her more than.
Well, Your Honor, when we talk about the best interest of the child, in this particular case, I want to show that, and also when we talk about substantial harm, I want to show that the grandmother is in no way harmful, and plus, she has a great relationship with Willow, who is the half-sister of Oakland, and because of all of this, the two of them have been separated as well. It kind of goes to how this is damaging to Oakland as well.
I'm going to overrule. I'm not, again, sure that this testimony is fitting within the criteria of the statute, but I'm erring on the side of allowing it in to allow you to present your case, but remind all the parties that I'm bound by the strictures of the statute in order to make this decision. So overrule the objection.
I thank you, Your Honor. Do you have other grandchildren?
I have our stepson and his girlfriend just had a little baby, Palmer, and I actually watch her while they work. She's
Have you ever
months old.
been accused of any type of crime?
No,
Do you abuse alcohol?
no,
Do you take any illegal drugs?
no.
Unlike a custody arrangement where the court is required to consider the best interest of the child and look at the background and so forth, the first step in this case is to determine those statutory factors. So I'm going to sustain the objection as to those questions.
I understand, Your Honor, and I was just going to the final in the statute when it does talk about best interest. I just wanted to show the court that the child would not be harmed in any way. But that's fine. I will move on. So finally, Ms. Neblett, as you probably heard now, the banter in the statute and the understanding of all that, Could you explain to the court why you should have visitation? And could you explain to the court why you feel that Oakland would suffer if you continued not to have visitation?
What sticks out in my mind is when I did have Oakland one time, she was going through my phone, and I'm a big picture person, and she said, Omi.
The objection?
I want Oakland to, I'm sorry.
The objection is based on relevance? Okay, you're about to repeat what your granddaughter said about that, so I would have to sustain the objection.
I'm sorry.
Well, Your Honor, though, this is not for the truth of the matter told. Then the relevance is how strongly the grandmother feels about this and why she brought the suit to begin with.
And which is not, it doesn't matter whether the grandmother feels, I take full understanding that Ms. Neblett has brought this matter because she loves her granddaughter and wants to be a part of her granddaughter's life. But the statute that I'm dealing with does not have a factor that how strongly does the grandmother feel. That's not a part of what I have to decide. So I have to sustain the objection.
Thank you. Yeah, once again, without any hearsay.
I can.
If you'll explain to the court, why should you have visitation?
I can. I should have visitation because I want Oakland to know me. I want her to know our side of the family. I don't want Oakland to feel uncomfortable. Dickson is a small town. Charlotte is a small town. We're going to run into each other. We're going to see each other, and we have. I want her to be comfortable coming to her grandmother. I want to be comfortable going to her. I want to be able to say, I love you. And I want to be able to say, I'll see you soon. If you need Omi, Omi's here. I want her to know that she has an Omi and a Poppy and a family that love her unconditionally and that she is loved.
Thank you. I have no more questions, Your Honor.
Ms. Roberts, you may cross-examine.
Your way of doing that is sending him a text message saying you're a fucking child abuser. Is that right?
No, ma'am.
But you did do that.
Yes, ma'am, I admit it.
And your husband threatened to physically harm him, correct?
That was a conversation.
Correct?
That was a
Answer yes or no, please, ma'am.
That was a conversation.
Your Honor, could you direct the witness to answer yes or no, if she can explain?
You must first answer the question you're asked, and then if you need to clarify your answer, you may do so. But
Yes,
you
he
gotta-
said that.
And that's not the, he's not just said that one time, he said it multiple times, is
No,
that
ma'am.
correct?
No, ma'am.
And you have sent vulgar and inappropriate text messages a number of occasions, haven't you?
No, ma'am.
Just one time is your testimony here under oath?
There's only one time I can remember, yes, and that was that incident there at the school.
And again, the way that you've couched that is that you found out that Oakland's class was going to the Adventure Science Center, the Children's Museum.
Yeah.
And that you asked and said you wanted to be one of the bus drivers.
Absolutely. I always let the bus garage know when I tell them, if a field trip comes up, either at Charlotte Elementary or Charlotte Middle, let me know so I can drive for my granddaughters.
Okay.
Yeah.
Did you ever contact and ask permission to do that with the father?
I didn't feel I had to ask permission. I didn't know I was on a no contact.
Well, how did you find out you were on the no contact list?
That day. The day of the field trip.
You just weren't on the pickup list, correct? There is no contact order in existence, is there?
I'm worried about saying, well, when someone throws their hand up and says she can't get on your bus, you're on the no contact list.
Have you been provided a no contact list?
No.
Have you been provided any order?
Never.
Okay.
I had no idea, which is why I took the trip. I was excited.
And was it your intention to go behind the father's back to have contact with Oakland?
Going behind his back, well, absolutely not. I had no idea I was on a no contact list. I was excited to go on a field trip to see be with my granddaughter.
Okay.
I saw it as
And
a
then you got
wonderful
angry-
opportunity.
You got angry about that and then sent this.
Oh,
Your Honor, I asked the question. That's already been answered.
I did.
Well, this is cross-examination, so I think she's entitled to ask the question in the manner she wishes. Overruled.
Not just, I'm angry, I'm upset, you're mean, you're hateful, you accused him.
I did. I was angry. I have been dealing with this for all of Oakland's life. I finally I was just so distraught.
And again, as your counsel said in opening arguments, and I want you to ratify, the purpose on you doing this is so that one day you can go to Oakland and blame her father.
I'm not blaming anyone. I'm not blaming anyone. So what I want to do, and the purpose of this, if this doesn't work out for me to see Oakland, I want her to know one day that I did everything that I could possibly do to see my granddaughter. And she'll know one day. But this has nothing to do with me blaming Colt.
And how old is your granddaughter today?
Oakland she should be 11.
And you have not had any contact with her in the past 3 years, is that right?
Since May, since that field trip.
And which was when?
May, and I think it was was it 23, May of 2023?
22?
No, 2023, so it's been 3 years.
3 years.
Mhm.
And prior to that, you went to ball games and visited her at ball games and things like that?
I did. I went to ball games and watched her play. Willow and I would go see her play. And before that, when it wasn't a ball game, like I said, I would meet them at Charlotte Middle, not Charlotte Middle, but at the CB store in Charlotte, and kind of like the meeting place. And I would get Oakland. I never heard that conversation. I think that was between my husband and Colt. I sent the text. I've admitted that. I never heard the conversation. But, I mean, that was, like I said, that was between him and Colt.
What grade, do you know what grade your granddaughter's in?
She's in 5th. She'll be at Charlotte Middle next year.
She plays sports?
Yes, ma'am. I keep up with her as
You
best
do.
as
You
as
keep
best
up
as
with her.
as best as I can.
And you know she's got a circle of friends?
Does she?
Well, you keep up with her, that was your testimony.
I don't know about her friends.
Okay.
But I do. I try to keep up with knowing did she love ball? Yes, she loves ball.
And doing well in school? Do you?
As far as I know, she's doing great in school.
And how would you? And
I
as far
would.
as you know?
Well, I mean, I wouldn't have anything. She's smart, from what I remember.
You ask questions of teachers in different people.
No, I do not.
You don't?
I wouldn't know. I don't know any of her teachers.
Well, yeah, your testimony was, I keep up with her. And so my question
if I
is, in what way you keep up with her? Do you say, hey, did you see Oakland? How's she doing?
You know what? She actually, there's a little girl on my bus that plays ball with her or used to play ball with her, and she'll tell me about, I saw Oakland the other day. Oh, did you? Where'd you see her? That kind of thing.
That kind of thing.
Yeah.
And so that she's held in high regard to that young lady?
Who is held in high regard?
Your daughter, Oakland, she comes up and tells you, this young lady on your bus says, oh, I saw Oakland today, and you'll ask, oh, how's she doing? And
I do. I said, where'd you see her?
And for all practical purposes, the information that you got appears that Oakland's doing well.
I mean, as far as a child says, a child's version of, yeah.
And you don't have those conversations with adults?
What adult would I have the conversation with?
I'm asking you, ma'am.
I don't know of any conversation I would have with an adult.
Okay, so you do not, sitting here today, you don't know whether Oakland's well adjusted or if she's having issues or anything like that. Is that correct?
I don't know where you're leading that. I
And
mean,
you don't have to know. You just answer my question. Sitting here today, you cannot give any shred of evidence to this court saying that Oakland is in any way, in any type of harm, can you?
If I tell you, it's hearsay. Right? So you just got on to me for hearsay. multiple times. I can tell you, but it's hearsay, so I can't do that because I will be shut down.
What
Right?
harm do you know
Mhm.
that Oakland is suffering with, by not having visitation? Not speculation, not conjecture. What harm do you know that Oakland is having?
Okay.
That falls on her?
I'll give you an example. So I was a RBT, which is a registered behavioral technician. My client was a student at Charlotte Elementary. I would work through a company called No Boundaries. So I would go to school and I would see Oakland from a distance.
And when was this?
This was probably 2 years ago. So I would see Oakland from a distance. There was one incident that sticks out in my mind, that it was an assembly, and I was in the gymnasium with my client, and the Oakland's class was getting an award or something, but they were walking around, and she saw me in the bleachers, and I saw her, and we looked at each other, but she didn't talk to me. I don't know why. She didn't talk to me. She's been directed not to talk to me. And
You
so,
don't know that.
okay, but
Do you?
so, I was on a no contact list, so, I mean, I didn't know if she knew that too. So anyway, she looked up at me and kind of cut her eyes up at me, and I looked at her, and I can remember mouthing, "I love you." And she looked at me and she smiled, but she put her head down and just kept walking back up the bleachers. So I tried to reach out to her in that way, just letting her know that I loved her, even just by mouthing the words. But I was never able.
So the answer to my question is you don't have anything to show that she's in harm's way right now. There's any significant emotional trauma befalling that child, do you?
It would be hearsay.
Your Honor, since she's been asked the question, she should be allowed to
No.
answer
Can
it,
I
even if it is
I
hearsay.
can.
Ma'am, if there's an objection, you need to be quiet while I hear it. What are you saying, Mr. Mize?
Well, my client is in fear of hearsay, though by answering Ms. Roberts' question, I'm just saying that she's allowed to answer the question if the question itself is asking for hearsay.
Your Honor, I was asking for personal knowledge, not of speculation, conjecture, innuendo.
Can I answer your question?
Of her personal knowledge.
Personal knowledge does not include hearsay statements, so I would overrule your objection. She's only limited to testifying. The statute requires there being some proof of substantial risk of harm to the child, and I think what Ms. Roberts is asking is, what evidence has Ms. Neblett, what can she produce that would show that substantial risk of harm or injury?
3 people have come to me, if not more, and have told me that Oakland is in physical and mental harm. And I do have proof of that. So this is what is encouraging me to drive forward for Oakland. I do fear for her.
Because she's not seeing you.
No.
Okay, that's all. Thank you.
Redirect?
Yes, Your Honor. Just on a couple of things that Ms. Roberts just covered, she was talking about, and we're trying to establish how Oakland would benefit and maybe suffer if not having direction. Going back to the gym and your description of that particular moment, though she didn't speak to you, what did you observe that indicated to you that she did want to?
There's a substantial list of objections, and I think you're asking her to interpret the reaction that the child had and in some way interpret that, which would be entirely subjective. Sustain the objection.
Thank you, Your Honor. And then just one other thing, at the very end, you were asked, the substantial harm now that you're in fear of is because you have had indications.
Sustain the objection, don't lead the witness.
Could you explain one more time what you were saying at the end?
Yes, I've had multiple people approach me that Oakland is being abused. I have picked,
Well, she can't repeat the statements, but she's listing statements from other people that is the basis for her concern or fear. But those statements are inadmissible. She can say she's had statements made to her, but then it doesn't carry any weight as far as meeting the requirements. Overrule the objection.
Thank you, Your Honor. So without stating specific statements made by others, why are you concerned?
I was so concerned at one point that I did a welfare check. I was concerned, I did a welfare check because I was so deeply concerned from the pictures that I had received from someone.
That's all I have.
I wanted to, since I have to make this decision, I would like to ask a couple of questions myself. Primarily, it has not been mentioned other than the fact that your daughter Morgan is nowhere to be found in this hearing. Why is she not here today? Do you have any idea?
I've asked myself so many times, why? And
Well, what is the nature of your relationship with your daughter?
my relationship with my daughter is good now. It's good. For the longest time, though, I didn't talk to her. She made a very bad decision years ago when the girls were little. And she made the decision she met a man and she moved to Ohio. And she left the girls here with their dads. Willow, I have a wonderful relationship with her.
And I'm really just, I'm,
Oakland, I've tried so hard. And,
well, listen to the question I'm asking.
okay, I'm sorry.
Your daughter is not here. Where does she live now?
She's in Nashville.
In Nashville?
Yes, sir.
And does she have any contact with Oakland?
No.
So she has no court-ordered visitation?
Can I speak to you freely without being worried about what to say?
I'm asking the question, so yes.
So, Morgan still has visitation. From what I gather, Morgan is very intimidated by Mr. Riddle. And so she is worried about the, trying to reach out to Oakland.
Well, my question is, if you can understand,
I'm trying.
if Morgan has visitation with these children, with Oakland,
Mhm.
then what is to prevent you from having contact with your granddaughter through
She
Morgan's
doesn't.
visitation?
She doesn't ask for the visitation. She doesn't
She doesn't
pursue
see
it.
her?
No, she doesn't pursue
Okay.
it, which is why I'm having to do this.
All right.
Sir, can I say one more thing?
No, I'm sorry. My questions are those questions that I have to ask, and it's not an opportunity for you to volunteer information. I apologize. All right, Mr. Mize, anything based on what I've asked?
No, Your Honor.
Ms. Roberts, anything based on what I've asked? Then step down if you will, please.
Yeah.
Mr. Mize, you may call your next witness.
Yes, my next witness is Kristen. That's right, Kristen Riddle. I think she's out in the hallway.
You'll raise your right hand and be placed under oath, please.
Could you state your name for the record?
My name's Kristen.
Full day, I'm sorry, last
Oh,
name.
Kristen Riddle.
Thank you. How do you know the respondent here, Mr. Riddle?
That's my ex-husband.
I'm sorry, again?
That's my ex-husband.
Thank you.
Pull the base of that microphone towards you and it'll be a little easier to pick up. Thank you.
Is that better?
Could you give a brief history of your relationship with Mr. Riddle when you met, how long you were together, that type of thing?
We met in 2020. We were dating for maybe a year when we got engaged, and then October of that same year of 2021, we got married, and then we got divorced in 2024.
Now, during that period of time, while you were with Mr. Riddle and living with him, who else was living in the home?
My son, Aiden, my daughter, Selah, in Oakland.
Who is the father of Aiden and Selah?
Aiden's dad, his name's Dylan. He lives in Kentucky. And then Selah's dad, his name is Bobby. He lives here in town.
And I think you explained this, but once again, how long were you and Mr. Riddle together?
About 4.5 years, 4 years.
As you know, we're here in an attempt for the grandparent to get visitation. Could you explain to the court, was there a period of time while you were with Mr. Riddle, was there a period of time that the grandmother, that Lori had visitation?
Yeah, she did.
With Oakland?
Yeah, she did.
And also with Willow?
Yes.
And so for about how long a period of time did that occur?
I mean, it happened for the first couple of years that we were together. He would work on Saturdays, so I would take Oakland to meet her so they could spend a couple hours together on Saturdays.
So how often?
I mean, it was like maybe, what, once a month, twice a month sometimes.
And could you explain to the court when you would make this connection, did you witness Oakland, Willow with Lori?
Yes.
The grandmother? Did you during that time have any concerns?
No.
And could you, just from what you witnessed, did they seem to be happy with the grandmother?
Yeah.
We're going to go to an incident that's already been discussed a little bit here, but do you remember delivering a letter to the school from Mr. Riddle requesting no contact between?
Sustained. Rephrase your question.
Did you ever deliver a letter to the school?
Yes.
Did you read that letter?
I wrote the letter.
You wrote the letter? Do you remember what was in the letter?
Yes, he had asked me to write a letter to the school stating that if myself or Mr. Riddle were not present, that Lori was not to be in contact with Oakland, or unless we had given permission.
Did you and Mr. Riddle have a discussion about this?
Yes.
Did he explain to you why he wanted no contact?
He just didn't want her to be around when he wasn't around.
Was Miss Neblett ever blocked from seeing your daughter, Selah?
No.
Was Miss Neblett?
It would seem to be irrelevant, sustained.
Let me ask you this. Could you explain the relationship between Oakland and Selah?
They were very close.
How is it relevant?
I want to demonstrate that Oakland had a close relationship with Selah as well, and that the severance of the relationship between the grandmother and Oakland had an effect on Oakland and Selah as well.
I don't know how this could relate to the factors that I have to consider, so I'm going to sustain the objection.
Did you ever witness I kind of covered this, but going back to the period of time when there was visitation allowed with Oakland, did you witness the two of them together?
I mean, whenever we would meet, like we would be in the parking lot for maybe 15 minutes or so they could say goodbye. But I mean, she always seemed very happy when she came back.
Did you ever have any concerns for Oakland and Oakland's safety when she was with the grandmother?
No.
So finally, as the court has explained, having been a part of the whole family for at least that period of time, do you think that Oakland would benefit from seeing her grandmother? It is a lay opinion.
It is a lay opinion, but that's not the standard that is the statute requires. Now, I mean, it may be ultimately whether or not it's in the best interest of the child, but we haven't reached that yet. Because it's a step-by-step, the statute makes it a step-by-step process. You have to prove all of the preliminary factors, and then only if I find all of those things to be true, does the court then consider whether it's in the best interest of the child to grant the request. So at this point, I must sustain the objection because of the fact that it's, in my opinion, it's premature.
Ms. Riddle, you were subpoenaed for today, right?
Yes.
Why did you want a subpoena?
I mean, I feel like,
How is it relevant, Mr. Mize?
I'll withdraw the question. That's all I have.
All right, Mr. Mize has withdrawn the question, so Ms. Roberts, you may cross-examine.
I live in Dickson,
Your address, please, ma'am.
5102 Green Park Drive.
5102, what?
Green Park Drive.
Green Park Drive. And you and Mr. Riddle, I represented him on the divorce.
Mhm.
And again, you've had no contact
No contact.
with him or nor with Oakland, is that correct?
Correct.
And y'all were divorced over a year and a half, 2 years, almost 2 years ago.
Yes, October of 2024, our divorce was
October
final.
2024. Thank you, nothing further.
Thank you, ma'am. You may step down. You are released from your subpoena. You may leave or you may stay if you'd like. Mr. Mize, you have another witness?
I do not, Your Honor.
He has rested his case. Ms. Roberts, do you have any proof you wish to put on?
Statutory admissions that were filed before this court shows that this woman has not had any contact with this child for a significant period of time. There's no presumption that there is a significant relationship. The testimony that's been elicited is that my client was married to her daughter. They have a child, Miss Oakland, who's now 11 years of age, that during the time that they were together and married, that she acted the role of a grandparent, and they had holidays, they did things together. After the party separation and my client was ultimately awarded custody of the child, that my client continued to allow some type of contact with the child for a period of time. And but there has been no contact between them for in excess of 3 years, basically. There's no testimony before the court showing that Oakland or there is a likelihood of suffering significant emotional harm. And for those reasons, Your Honor, we would request that this petition be dismissed.
It's hard for me to believe that we're here, Your Honor. How many times while sitting in your position have I said to myself, why can't we just work this out? As I said to my client, this is a tough road. Grandparent visitation isn't the same. We've been discussing the statute, and everyone here is well aware of it. And as I said, we must show that she was blocked. I believe the testimony has shown that, not only by my client, but also by Ms. Riddle, that my client has been blocked. We must show that there was a significant relationship with the grandchild. I believe we have shown that through testimony. We've shown that through the sporadic periods of time that my client was allowed to see the grandchild, and then the times that she was shut out. And then, of course, as we've been discussing often today, we must show that there's at least a danger of harm to the grandchild if she doesn't maintain a relationship with the grandparent. That's a tough one. I would hope that the testimony of my client, that she has seen the grandchild has at least seen her and drops her head. And finally, the court must determine if it's in the best interest of the child to have the relationship with her grandparent. I knew none of my grandparents. Both my grandfathers died before I was born. My two grandmothers were in Germany. I met one grandmother one time when I was 7 years old. I would give anything to be able to have that relationship. But I couldn't. In this case, it's possible, but it's been blocked. As you could probably well see, and I know that this court already in its responses knows that this grandmother loves her grandchild deeply. And it's even more hurtful that there were times when they were able to establish this very strong bond, and then it was taken away, and then brought back, and then taken away. That is substantially harmful to the child. And I would ask, as I said before, my client's response is, I want my Oakland to understand that I did everything that I could. So there it is, Your Honor. Thank you.
This court is bound by the language of the statute and the requirements that are set forth, and by the case law interpreting those. So I'm going to take a short recess and look at some case law on this point, and you have something you wish to submit. All right, we'll take a short recess and let me look at the case law, and then we'll come back. All right, I've reviewed the authorities and the statute and prepared to make my ruling, but let me preliminarily first say this. I'm a grandparent. I have two biological I have three biological grandchildren, and I have four step-grandchildren, 5 grandchildren. I have a total of 8. And every week, I have some contact with them, and I believe it is in their best interest to have contact with their grandparents and so forth. So I'm a firm believer in the fact that grandparents contribute a lot. Like Mr. Myers, I had very limited contact with my grandparents. My grandmother died when my mother was 6 years old, and I never got to know my maternal grandmother at all. My grandfather on that side was an elderly man from as long as I ever knew him, and he was a farmer, and then he didn't live long past my high school days. So I really had very little interaction with, on my father's side. My grandparents were country folks and lived in Sardis, Tennessee, or Saltillo, in Hardin County, and I had very little contact with them. Contrast that with my children and the interaction with my parents, who are their grandchildren, and I think it definitely was a beneficial effect on them. So I am a firm believer in the fact that grandparents should have a relationship with their grandchildren, and that grandchildren and children in general benefit from that. But my personal beliefs are not the controlling issue in this particular case. And has been pointed out by Ms. Roberts in our Tennessee Supreme Court, and I'm reading this into the record because I want the parties to understand the restrictions that are placed on the courts in determining these cases. Our Tennessee Supreme Court has said that the right of a parent to raise a child is a fundamental liberty interest protected by the 14th Amendment to the United States Constitution in Article 1, Section 8 of the Tennessee Constitution. They're referring to that in Hawk versus Hawk, which is 855 Southwest 2nd, 573, a 1993 Tennessee Supreme Court case. Parents' rights to the care and custody of their children without undue governmental interference is among the oldest of the judicially recognized liberty interests protected by the Due Process Clause of the federal and state constitutions. I'm skipping on down to some of these rulings. Neither the legislature nor a court may properly intervene in parenting decisions absent significant harm to the child from those decisions. The substantial harm requirement protects parents from unwarranted state interference in the parenting process. Absent substantial harm to the child, a trial court lacks a sufficiently compelling justification for interfering with the parent's privacy rights by ordering grandparent visitation. The substantial harm component has thus been described as the threshold question in grandparent visitations cases, and that's citing the McGarity versus Reynolds case, which is a 429 Southwest 3rd, 562, 570 Tennessee Court of Appeals decision in 2013. The decisions of the United States Supreme Court and Tennessee Supreme Court interpreting the federal and state constitutions explicitly prohibit any judicial assumption that grandparent and grandchild relationships always benefit the child as contrary to the parent's fundamental right to raise their children. And that particular provision hit me hard because I do tend to think that I do presume that a grandparent-grandchild relationship is in the best interest of the child. But as our Supreme Court and United States Supreme Court, my belief cannot be applied in this case to render a decision that is contrary to the law. So when looking at the statute that we're faced here, the first step is to determine whether or not there's even a grounds or an application of the statute, and the court does find that the statute would come into play because under that statute it says that any of the following circumstances when presented in a petition for grandparent visitation goes on to talk about if the grandparent visitation has been severely reduced by the custodial parent or whatever, that subsection 2 of that is that the child's father or mother are divorced, legally separated, or were never married to each other. And it goes on to talk about other factors that could come into play. Clearly, these parties, the biological parents of this child, were divorced and are not together, and as a result of that, the statute would have application. But then in subsection B1, it says, in considering a petition for grandparent visitation, the court shall first determine the presence of substantial harm to the child. Such finding of substantial harm may be based upon the cessation or severe reduction of the relationship between an unmarried child and the child's grandparent if the court determines upon proper proof that A, the child had a significant existing relationship with the grandparent, that a loss or severe reduction of the relationship is likely to occasion severe emotional harm to the child. It goes on to say, subsection B, that the grandparent function as the primary caregiver such that cessation or severe reduction of the relationship could interrupt provision of the daily needs of the child. That doesn't apply in this case. Subsection C, that the child has a significant existing relationship with the grandparent and the loss or severe reduction of the relationship presents the danger of other direct and substantial harm to the child. Clearly, there's been evidence in this case that there was a relationship between Ms. Neblett and this minor child, and that up to a certain point, she had regular contact with the child and had a beneficial relationship with the child. That relationship ended, and there's really no proof before the court as to why that relationship ended or why the father, Mr. Riddle, made the decision to terminate that relationship. Obviously, the biological mother is not present and therefore has very little impact in this decision. But there's really no proof before the court as to why this relationship was terminated or why it ended. But it was terminated, and there was a finding, or is a finding by the court that relationship ended. So what do I have in the way then of any proof of substantial harm or injury to the child or danger of substantial harm or injury to the child? And essentially what I have is the fact that Ms. Neblett is a grandparent who loves her granddaughter, had a good relationship with her, and wants her to have an opportunity to know that side of the family and to have a relationship with her biological sibling, and that she fears that that's going to be a detriment to the child in not having that. Unfortunately, this court's finding research that I have conducted in this case indicates to me that that does not rise to the level of a substantial harm that the statute would require. And I'm going to refer to some findings of the Court of Appeals in the McGarity versus Gerald's, which is cited already. It's the 429 Southwest 3rd 562, a 2013 Court of Civil Appeals case. And in that instance, the trial court granted the trial court granted the grandparent visitation based on the fact that there was two instances that indicated that the child had a good relationship with the grandparents and might have been upset about seeing the grandparent or hearing the grandparent's name. They went on to state that essentially there are only two instances regarding this child supported by evidence in the record that grandparents used to support their harm argument. First, the grandparents point to the testimony of witnesses to a number of exchanges between grandparents and appellants prior to the cessation of visitation. The witness testified on numerous occasions the child cried when grandparents returned the child to the appellants and indicated he did not want to leave the grandparents' care. Next, another witness testified she saw mother and child at a retail store after the cessation of visitation. When the witness asked the child about grandparents, the child became excited and repeated the name Nana, which is how the child refers to Mrs. McGarity. But the court went on to say there was no evidence in the record that the child suffered any ill effects due to the cessation of the grandparent-grandchild relationship. In this case, there is no evidence before the record that the child in question, Oakland, has suffered any ill effects or trauma as a result of the cessation of the visitation between her and the grandmother. Instead, in the, again referring to McGarity, it says, instead, the evidence showed only that the child became excited at the mention of the grandparents, not that he became inconsolable or otherwise upset due to the loss of connection with them. Feelings of excitement do not rise to the level of other emotions of embarrassment, anger, chagrin, disappointment, worry, or nausea. There is simply no evidence in the record to support a finding that the child will likely feel inadequate, abandoned, rejected, or that he will lose connection with his heritage, or that he will suffer economically if visitation is not granted. The court in that McGarity case simply found that the cessation of visitation, it was not shown by the grandparents that the cessation of visitation is likely to have any substantial harm to the child. In this case, I would love to be able to find that there is a basis for awarding grandparent visitation, but the statute does not allow me to do so because there has been no finding that there is a substantial harm to the child by the cessation of the relationship, or that there's likely to be a substantial harm. It would be my hope that perhaps the biological mother can get her act together and have regular visitation, and that somewhere along the way that would allow Mrs. Neblett to then begin to have a relationship with Oakland again through her visitation. But in this court's finding, the petitioners have simply failed to meet the burden, the threshold question, and therefore the court finds that the petition should be denied. Ms. Roberts, you will draw the order, please.
I did file and ask for attorney's fees in the initial case that was misfiled, then refiled in this case, and I gave notice, although the case that I passed to you earlier had said that the court can't just, absent another finding under the American rule, that attorney's fees can't be assessed necessarily in grandparent visitation. But given the fact that there was a filing, motion to dismiss, and then a refiling, I would just leave it to your honor to determine whether or not that would be granted, because again, I did file and ask for sanctions under Rule 11.
I appreciate that. I am not inclined to grant attorney's fees in this case, and therefore I would not grant it. So that's fine. I'll make that ruling on the record. I hope that someday things can somehow transpire that would allow the parties to do, have an opportunity for both sides of this child's family to come to peace. The child has a right to know both sides of the family, but Mr. Riddle, you're the father, and you get to make those decisions, and I don't know why it's terminated, and you may have a completely valid reason, and obviously the text messages were inappropriate that were sent, and the threats that were made, I understand that, but perhaps with the passage of time, things can be resolved that would allow a better relationship. And as the child grows, when she gets to be 18, she can go see her grandparents if she wants to or not. You can't stop her. So, all right, that will be the ruling in this court. Ms. Duke, we're past the noon hour. I assume we can take your case up when we come back after lunch. Okay. Then we'll stand in recess until what? Let's make it 1:30. We'll be in recess to 1:30. All right, we are ready on our last case.
Like for me to have you move up here?
Yes, he needs to come up there. This is Jonathan Scott Marcello versus Whitney A. Marcello. It's a hearing on a motion to suspend visitation pending a final
Precedent
hearing.
stays on.
Ms. Duke, I believe you had filed this motion, so is your
Yes, Your Honor.
ball is in your court.
The mother has no problem with visitations occurring in Tennessee. No problem at all. So while it's a suspension of visitation, that would be for purposes of outside the state of Tennessee. Your Honor, we're before this court asking to suspend visitation pending a final hearing in this matter. Petitioner in this case has had the minor children in her care and custody solely since February the 20th. The father has not exercised his regular and routine visitation during that time period. I will say that the mother has offered, when the father has come into town, to allow him, his regular visitation, which he has exercised, and things have gone fine. She has asked, based on the fact that the stepmother has not submitted herself to the Department of Children's Services to complete all the tasks required of her, that the stepmother not be involved during this process. Department of Children's Services opened up a case on this matter when it was reported that the minor child was being pinched on his penis by the stepmother. It was reported and DCS investigated. DCS required several things of the father and several things of the stepmother. To my knowledge, father followed through with what he was required to do. Stepmother did not. Stepmother moved to Florida and DCS had to close their case because stepmother was outside the jurisdiction of the Department of Children's Services. Regarding the main crux of this is that pursuant to the relocation statute, the father was to give notice of the relocation, which I will give him credit that he gave most of the criteria on the relocation notice. But when the mother, by and through counsel, expressed that there was an objection to his relocation, he still relocated without leave of the court. The court did not give him permission to leave, and so we're before this court now asking about potentially changing a parenting plan in the interim, which a relocation is the only exception that you don't necessarily have to show irreparable harm, though I've alleged it in my motion. You don't have to show irreparable harm in order to change what the visitation arrangement is. Father is appearing before this court with unclean hands as he has moved without this court's permission, as I've already said. We attended mediation, which unfortunately was not fruitful. Subsequent to mediation, 3 months after the last time he had exercised visitation with the minor child, substantial visitation with the minor child.
So how long has it been since he's seen the child?
The children. His last overnight visit was February the 20th, so almost 3 months. The visitation subsequent to that was when we had mediation in the last 2 weeks we had mediation. So when he was in town, the mother made sure that the children got to spend time with him. So that would be towards our irreparable harm in that the kids have not been with him, do not know anything about this new home where he is. We don't know anything about the new home where he is. The kids have been reluctant to spend time with him, though I will say, and I think the mother would say to the court, that visitation did go well the days that we had mediation. Our biggest concern is that father, without any consideration for the mother and his move, after mediation didn't work out in a point of retaliation, told the mother what visitation he was going to be exercising in the near future. and that he would be exercising it in Florida, and that he would be going all over Florida, visiting different people, and that the stepmother would be around the children, even though stepmother has not submitted herself to the department as she was supposed to, or completed the tasks. I think she did one of the tasks, but did not complete the rest. So those are our biggest issues. I know that there were some issues in the home, fighting and yelling between stepmother and father. I don't think the father's going to be able to testify that he actually gets along with his wife, but their moving to Florida was an exercise in trying to avoid responsibility here in Tennessee. But again, mother's willing to work with him provided that anything is occurring in Tennessee. Even overnights for the father, if they're in Tennessee, is more than fine. But right now, until we have a final hearing on the relocation matter, we're not in agreement to allow the visitation to occur as set forth in the parenting plan. We've got 2 children in this case. One child is almost 11 and one child is almost 5.
Mr. Marcello, do you wish to make any sort of opening statement? I'm going to give you a chance to testify, but opening statements are usually just where you tell me what your position is. No, you don't have to be under oath.
Just for the record, Miss Duke.
Miss Duke.
Miss Duke, the opening statement was that my wife pinched his penis. So this would be the first time I've ever heard it, and the pictures and the accusation that was made from that side was his thigh that was on the side. So I'm not sure where she's getting any type of sexual misconduct or whatever you would want to call that. So I just want to put that as a record.
Okay.
The move was planned way ahead of time. It was before, I think the accusations started October. We were planning July, August, when we first started talking about it, whenever I was talking to my brother. And I talked to Emerson about it, make sure that it was okay with her, because obviously a 30-day notice to my daughter is kind of short. I followed the parental agreement where it said to give them a certified letter within 30 days. I let her know ahead of time, and I also sent the certified letter to Whitney and her lawyer. The only thing I got back was that they didn't agree to it. I didn't see anything signed by a judge saying that I could not move. And I didn't see anything in the parenting agreement that said that I couldn't move. It's just obviously the parenting plan, the schedule would obviously not be the same due to relocating out of state. But the accusations are unsubstantiated, and it's just, for me, it's just a flashback of the first time, and I just don't know where they're getting, because I was going to bring pictures or videos of the children, but obviously with it being live stream, I don't know how about to, give evidence of Lionel before and after accusations with Tara, including Emerson, because she's in the house too. And they both enjoy being around her, and the kids have never been sent to an emergency room like they have with Whitney with an incident before. If they were sick, I brought them to the doctor. Whitney has had me, or I shouldn't say had, I volunteered numerous times to watch the kids while she was working. So there was even times where there was possibilities that I couldn't watch the kids during my scheduled time, and I would ask her if she wanted it, and she declined, so I don't see how there's a threat in the household if she's...
Let me interrupt you for a moment and explain. This hearing today is only about a motion to suspend the operation of the original parenting plan, because under that parenting plan, you were to have contact with or visitation with the children every Thursday. From Thursday at 5 p.m. to Sunday at 6 p.m. every other week, and then from Thursday at 5 p.m. to the following Friday when school begins in the alternating week. And I would assume you would agree that that would not be possible if you're living in Florida.
Correct, sir.
So the hearing today is to suspend the operation of that and to determine what, suspend the operation of the parenting plan, since it's not workable if you're living in Florida, and then to determine what, if anything, what other kind of schedule would be appropriate.
Yeah.
On a temporary basis, because right now, if I rule that you are not entitled to move to the state of Florida with that because you didn't comply with the state regulations, then, then we'll have to do something different. But right now, the only thing that before the court is the issue of what are we going to do on the interim period until there's a final hearing. So,
Gotcha.
all right.
So the only thing I did request was after mediation, almost immediately, because in the parental agreement, it said that you have to have your week for the summer given to the other parent by May 1st or before May 1st. So I did that. And that was the only thing I did.
All right. Well, let me hear what Ms. Duke has to say, and then we'll go from there. Ms. Duke, you may call your first witness.
Judge, I call Whitney Marcillo.
You will come around, please, ma'am. Come around here and raise your right hand and be placed under oath.
Ms. Marcillo, is that a copy of the notice of intent to relocate that Mr. Marcillo gave you?
Yes,
Okay. And you acknowledge receipt of his intent to relocate, is that correct?
I did.
Okay. In that intent to relocate, does he give you a physical address where he plans to move?
No, it just says Central Florida.
Okay. He doesn't even give you a city, does he?
No, he does not.
And pursuant to the relocation statute, based on your knowledge of it, you're entitled to a physical address and a city where he's planning to move. Is that correct?
Correct.
All other requirements of the relocation statute as far as notice are concerned were met with this letter. Is that correct?
As far as I know.
Judge, I'd submit that as the first marked exhibit.
Mark it as Exhibit 1.
Did you agree with his notice to relocate?
No.
Okay. And did we file an objection to the notice to relocate? Gave him notice that we objected?
Yes.
At any point in time pursuant to statute, did he file a petition to change the parenting plan prior to relocation?
Not to my knowledge.
Did you end up having to expend attorney's fees in order to file a petition to modify the parenting plan because he was going to be relocating?
Yes.
And when did he relocate?
February, the end of February.
And since February the 20th, have your minor children spent the night with him?
No.
Have your children been doing really well?
They have, yes.
Now, that being said, are you trying to keep the children away from Mr. Marcillo?
No. As when we had mediation at the end of April, I allowed him both a Tuesday evening and a Wednesday evening visit with the kids for dinner and just asked for them to be returned prior to bedtime because they were school nights.
And did you two work that out just fine?
Yes.
Okay. What is your only request mainly for visitation purposes, or what are your two requests? That they be in are you asking that the court require that his visits be in Tennessee until we get this case resolved?
Yes, I have told him that I don't have any issues with him coming to exercise anytime in Tennessee and alone, just for the safety of the kids.
And Department of Children's Services case was opened on this, is that correct?
Yes.
and there were two pinching incidences, is that correct?
No, there were multiple.
Multiple, okay. Tell the court a little bit about that.
Yes, so over the summer, I started noticing that my then 3-year-old son was having a lot of anxiety at exchanges. When I'd addressed this concern with my ex-husband, Mr. Morcillo, he kind of shrugged it off. He told me that he didn't have any of those issues, despite both of the kids calling me every time they were with him. So I let him know that I was going to choose to sign our son up for play therapy. When I signed him up for play therapy, he started telling me and the care manager and therapist that my ex-husband's wife, Tara, was pinching him. And then he had been coming home with bruises. So I asked him what happened to his thigh. He had a large bruise there. He said she pinched him. And then this was almost an occurrence with every visitation. There was one visitation where I had to bring him to urgent care and have his injuries documented because he had a mark on his chest that ended up scarring. And then he had 9 bruises over his back, on his buttocks, and his thighs.
Okay. And did urgent care contact the Department of Children's Services in order to have this matter investigated?
They said they were going to.
Okay. And did DCS reach out to you and reach out to the father, to your knowledge?
To my knowledge, they did. And then I updated them with all future incidences, like Christmas Eve when my son came home and said that the stepmom had pinched him on the penis as punishment.
And at this point in time, did you express to Mr. Morcillo that, hey, it's not an issue for you necessarily, but you don't need to leave the children alone with your wife?
I communicated with DCS, and she communicated that due to our high conflict at times nature. And I know that when I have addressed certain things with him myself, it tends to come off and he can get defensive at times. So I didn't want to upset him. So I asked DCS what their recommendations would be, and I had made sure that they had aligned with what I was going to say to him because I didn't want to repeat anything unnecessarily. So the caseworker said that she was going to tell him to not leave the children unsupervised with his wife and to make sure that he did not delegate any discipline or childcare or bedtime routines to the wife as well.
And after DCS told Mr. Morcillo that he could not leave the child alone with the stepmother, did he send you a notice of intent to move to Florida?
Yes, he also stated in parenting messages that they're never alone with her for more than 15 minutes at a time.
And during this time period, did the Department of Children's Services have things for all of you to do, for Mr. Morcillo and for the stepmother to do?
Yes, for the both of them.
Okay. And to your knowledge, did Mr. Morcillo complete what he was supposed to do?
To my knowledge.
Okay. Did Ms. Morcillo complete the task that she was supposed to complete?
To my knowledge, his wife had only completed half of them.
And when he up and moved, what did DCS do at that point?
We had been transferred to family services by that point in time, and they told me that due to the jurisdiction issue of them being in Florida, Tennessee would not be able to pay for any services due to that relocation issue, and therefore they were forced to close the case.
And at this time, are you asking that the stepmother, until she's resolved her issues, the stepmother's contact with the minor children be limited or supervised or not at all?
I would prefer for her contact to be preferably not at all. I feel like that's the safest avenue, especially with the anxiety that my youngest seems to have at the mention of her name.
Now, admittedly, the minor children had a decent visit that Tuesday and Wednesday, or Wednesday and Thursday after the mediation, is that correct?
Yes.
And did you receive an alarming text message from Mr. Morcillo about what visitation he intended on exercising?
He had told me when we exchanged the children after mediation that he would be exercising his week of summer visitation for his summer vacation week for the week of Father's Day. And then he sent me that in a text message, in a parenting app message as well. I asked for details regarding that because if he was coming to Tennessee alone, I would have been more amenable. But he had told me that he would be going to Florida to exercise his time down there.
And did he tell you he would be doing this?
Yes.
At any point in time, did Mr. Marcillo come into this court and seek permission to move to Florida?
Not to my knowledge.
And based on your understanding of the statute, he would have needed to do that. Is that correct?
Yes.
Okay. Judge, if I may have one moment. Do you have a physical address for him now?
Yes, I believe he shared one.
What is your proposal in the interim to try to the visitation with their father?
I have them both in therapy. I would propose that anytime their father comes to town to see them, I mean, I'm more than happy to allow him to exercise those visits. If he is alone, I don't mind if it's an overnight visit, with keeping in mind any school days that it may be surrounding, so that they can have as much consistency as possible.
So as long as it's in Tennessee, you're okay with it, provided that he is by himself and not with the stepmother?
Correct.
For the short time period that DCS required him to supervise the stepmother with the minor children, did he follow through with that?
Not as far as I know.
Are you concerned about the health and safety of your minor children and the fact that they could be irreparably harmed if they're required to go to Florida?
Yes,
Now, you've got a minor child in school, is that correct?
I do.
Okay, and the other one is in daycare.
Yes, and he also receives speech services.
Okay, tell the court a little bit about his speech services.
So my youngest son is 4. He goes to speech therapy twice a week. He's been in that specific speech therapy for about 1.5 years now. If he misses a certain number of appointments, then they will remove him off of their speech appointment roster, and he will be moved to the wait list, which is about a 12-month wait list at this time.
Okay, so tell the court, how often is he going to his speech appointments?
Twice a week.
Twice a week. And so if he misses 3 speech appointments in a row, so a period of 10 days, you would have 3 speech appointments. Is that fair?
I'm sorry?
In a period of about 10 days, would you have those 3 speech appointments that he would need to be going to?
Yes.
Okay. If he were to miss by going to the father's house for any 10-day period of time, would that reset him in the speech world?
It can.
Okay. Have you been the one providing most of the care for purposes of getting the child to and from speech appointments?
Yes, if it, on Wednesdays, it normally happens in the afternoon, so if I'm working, I normally delegate that transportation to family.
Okay. When you heard the father say that they didn't move because of DCS getting involved in the case, that they had been planning it since August, was that a surprise to you?
Yes.
Okay. At any point in time between August and February, or between August and the time that he sent the intent to relocate, I don't have the date right in front of me. What was that date? Do you remember?
I'm not sure what the date was on that letter, but I know that he first brought it up to me in messages around Thanksgiving when he started canceling parenting time.
Okay. And at Thanksgiving, did he miss an entire 5-day period of time with the children?
Yes, he said that it was surrounding DCS for reasons of why he wanted to cancel his time, though he did ask to take them out to lunch that Saturday, which I allowed for him to do, and then returned them to me in the evening per his choice, but he did cancel that entire Thanksgiving break.
And did he miss visits off and on until February the 20th?
I don't believe he missed any visits in December or January or February, but he has routinely missed them beforehand.
Okay, but beginning February the 20th, he has not had them overnight.
Correct, yes, he's missed all visits since February 20th.
Are you concerned for the health and safety of your minor children having to go into a home, number one, that they don't know, and number two, into the home of the stepmother that's not completed what she was supposed to complete pursuant to DCS requirements?
I am, yes.
Okay. Are you also concerned that since they've not really spent the night with the father since February the 20th, that there'll be a little bit of a readjustment when they do spend the night?
Yes, I do, and from what I have gathered at their therapy appointments, it's also a concern that's been shared and reciprocated back to me.
Okay, it's a concern of the therapist also, is that what you're saying?
Correct, yes.
Okay. Judge, I'll tender the witness.
Mr. Marcello, you're acting as your own lawyer. You have the right to ask questions. If you want to do that, you may do so now, but they must be in a question form. I'm going to give you a chance to testify and make your statement. You have questions? All right, come up to the podium.
Before mediation, you gave a preferred parenting plan, what you would expect for out of state. And in that, you allowed 4 weeks a
Judge,
year.
I'm gonna object because I think that was in,
No, it wasn't mediation.
And she's objecting. You wait till she finishes.
Judge, that was, number one, settlement negotiations, and number two, it was in preparation for mediation.
All mediation, anything that happens in mediation is confidential and is not to be introduced in a hearing. The reason for that is because under the mediation rules, if both parties have a freedom to discuss whatever they want to discuss without, and make offers without thinking it's going to be used against them in a proceeding, then that would make the chances of resolving the case greater. In addition, there is a rule of law that says a offer of settlement cannot be introduced in a trial. It can't be done because, again, for the same reason, it would inhibit people from trying to settle cases if they make an offer to settle that they know is going to come back against them. So
This was before mediation, and it's before any, as far as I know, before she even contacted a lawyer.
So what is it?
What, the question?
No, what is the thing that you're wanting to ask her about?
Oh, she offered 4 weeks overnight while I was in Florida, and then.
And again, that's the offer that you're talking about. Is an offer of settlement in this situation. So if
Even though it
you
was
can
before-
ask her if she was ever agreeable to you having overnight in Florida without making the actual relegation or the specifics of the order.
Ms. Morsillo, were you ever inclined to having me have the kids for week-long periods overnight in Florida?
I know that it was discussed as a possibility, but I had never agreed to that.
And there's been time, or have you ever been offered extra time with the kids and declined even after the allegations were made?
I mean,
I'm gonna object as to relevance. I don't know what relevance that has.
What's the relevance? Relevance means that the information you're seeking would make something more likely true or not true.
Yes, I'm trying to prove a point or give information that the safety of the kids is not her first concern. So whenever she was given an opportunity to keep the kids allegedly safe, she declined.
Well, I'm going to overrule the objection and allow it to come in. It may not be relevant, but we'll see. Go ahead.
I've offered you times, or there's been times where you've been offered extra time due to conflict in my schedule, and you declined it and saying, no, you should watch the kids. So why didn't you allocate that time to yourself if the kids were threatened?
I don't remember any time that I've declined receiving more time with the kids outside of one day where I was out of town, and that was July of 2024.
Do you recall the weekend that you made the first allegations of child abuse in my household, in Tar's household, Tar Morsillo's household?
I mean, I don't remember the date, but I know it was around September, October.
Okay. And that was that the same weekend that your biological mother and stepfather came to visit?
I don't believe so. I thought they were in town the following and during the fall break period.
Was that also the same weekend that you broke up with your fiance? Tyler I don't know his last name, but I know his name is Tyler, and I'm assuming it's the only fiance that's named Tyler.
We weren't engaged. We were just dating. However, no, we did not break up that weekend.
Okay. The first allegations that were made, Lionel had pinch marks on his thigh. Is that correct?
Yes.
What color were the bruises from the pictures of Madison?
When I noticed the bruising, I believe it was purple.
Okay. I want that for the record.
What for
That,
the record?
she's claiming that the pictures that were provided were purple bruises.
Were what?
Purple. The bruise color was purple.
Okay.
So I just want that for the record that so, sorry, I'm a little nervous. Since I moved to Florida, your claim was that the kids are happy and carefree. Does our daughter Emerson Morcello text me claiming that she misses me?
As far as I know, I don't check her text messages routinely.
She has a smartphone, correct?
Yes, she has an Android.
Okay. As a parent, you don't feel there's a need to check that phone because she has a smartphone and she has access to things that she shouldn't?
It has parental controls on it.
And what do those parental controls monitor?
It monitors any contacts that she adds, so all of her contacts are approved through me. It monitors all of the access that she has to various apps. She does not have internet access on there. And then her photos are all backed up to a Google Photos so that I can monitor things that she's doing as needed, but she's been very responsible, so I don't feel the need to essentially look over her shoulder for every single day.
The first month of March, the first month I was gone, which was March, Lionel had his tonsils taken out.
Yes.
Did Lionel call me 2 times within 2 days, crying that he misses me?
Yes, he had a very hard week. He was on recovery for 2 weeks. He felt it was unfair that you were not in person for him when he was having a lot of pain. So I offered to FaceTime you to see if that would help him feel better, to be able to see and connect with you there.
On occasions, Emerson, who has freely use of her smartphone, is approximately maybe 20 feet from Lionel's bedroom when we were living in Franklin, Tennessee. At any point, did Emerson make any claims that there was abuse going on?
She told me that she was in her bedroom all weekend when she was at your house, and that if Lionel came into her room, that she was told to keep the door open, and frequently y'all would come in and take Lionel out of the room if you heard him talking on the phone. So she was unable to provide any kind of knowledge of that kind to me.
On the parenting app, everything is recorded, including what you would call video time. It was being recorded, to your knowledge, correct?
Yes.
Was there a night where you tried talking to Lionel and he declined, and he specifically said he did not want to talk to you?
Yes, I believe there was a moment where he had been upset or tired. I know that he had been, if it was the weekend after Christmas that you're referring to, that's the weekend that I'm referring to, and I had been on an airplane, as well as out of town that weekend. And he had called me, but he had seemed quite tired and upset. So
Before allegations were made, I believe September, October, I don't know, officially documented with DCS, it was October 14th that she reached out to me. Were you confused as to why, with all the hearsay or documentations from Lionel, that they did not stop parental time with me overnights?
No, the DCS caseworker explained that due to the fact that you had less than 50% of your parenting time and had been canceling your Thursday overnights for over a year, that they were not able to put a safety plan into place to limit the custody time.
With the changing in parenting plan and your documentation to the courts, you mentioned that I verbally changed the documentation. Do you feel like you partaked in that specific changing of the plan?
I was in agreement to keep the kids on every Thursday overnight and then move your every other weekend from Thursday evening to Sunday evening to Friday after school to Monday morning, because I felt that it was in the better interest of the kids because they were less tired and Emerson's grades improved in school.
And with that change of the agreement, why with your lawyer would you say that I, myself, and not we changed the parenting time with the children?
I think she can answer why her lawyer would do something.
I don't believe, I don't
okay.
think she can answer the question that you're asking, which is why her lawyer would have said or done anything, unless she told her lawyer to say it. You can ask that question.
Did you tell your lawyer to write that I alone changed the parenting agreement?
I mean, I don't recall.
I don't think that's been said anywhere.
Don't think what?
I think that's been said anywhere.
It was said in the first documentation that she sent me the first time, whenever relocation was mentioned. It's in the court documents filed with Lynn Collins. She's the only name I remember on the document.
Well, I don't see how it's really relevant, so let's move on.
Okay. Do you feel that I have the best interest of the kids?
No.
And why would that be?
I don't feel that you have the best interests of the kids in regards to keeping them safe when your wife is around.
So you would claim that I would put Tara Morcello ahead of the children's safety?
Yes.
Is there a reason why you would feel that?
Because our youngest son has had countless bruises coming home from your house despite DCS involvement. You relocated despite my objection to the relocation to Florida, instead of allowing her to complete the DCS task requirements. The main piece of which she did not complete was the parenting assessment with the parent observation that would allow a DCS caseworker to see how the kids interact with her in person in real time.
So it would be safe to say that you feel Tara and I have dodged DCS and for the 1 week family services?
Yes, but family services was involved for about 2 months.
Their communication was only maybe a week.
Yeah, testify, you're asking questions.
Yeah, so with DCS's involvement, they claim that there was no threat in the household and that the most she would do was implement best practices. Were you aware of that?
That is not what they'd shared with me.
Are you aware that the only thing that Madison said for our household was for myself to make sure that I put Lionel to bed? And if there is any discipline outside of obviously any type of physical, which is not allowed, but any type of discipline that I would be the one to administer it. Were you aware of that?
I'm aware of what she shared with me, which was those aspects and then additional.
Your assumption is that there was a delay in us taking the assessments and evaluations. Is that correct?
I'm not sure. I know the DCS had a delay in scheduling those services and getting in contact with the practitioners who did the assessments and observations.
Why would you assume at that point then that in your paperwork that you filed that we were dodging DCS then?
Because you moved before tasks were completed.
That's not. That's all I have, Your Honor.
All right, thank you. Anything?
No follow-up.
Thank you, ma'am. You may step down.
Thank you.
Ms. Duke, you have any other witnesses?
I don't, Your Honor. That's our proof.
Plaintiff or the petitioner has rested their proof. If you wish to testify, now would be an appropriate time. Do you want to testify? All right, then come forward and raise your right hand. Raise your right hand and let the clerk place you under oath. All right, thank you. Have a seat. This is your opportunity to testify about the circumstances and what's being asked here. So I'll hear whatever you have to say.
With Whitney, ever since we first separated, there's been friction when it comes to co-parenting. Whether it's she feels what's best for the kids or what I feel is best for the kids. There's a track record of people that have any friction against Whitney that she will try to block them completely out of the kid's life. She had friction when her mom testified against her, and she tried everything to.
Judge, I'm going to object if this is outside the scope of today's hearing, which it is, if it goes back farther than.
All right, keep in mind that the sole purpose of this hearing is for me to determine what should be your schedule with the children since you have moved to Florida. You have moved to Florida, correct?
Yes, sir.
And that because you have moved to Florida prior to getting court authorization, then the now question is what schedule is going to apply and where you're going to exercise your visitation. So anything else is not really relevant about that. Your past history is not relevant unless you have some reason to believe that it's relevant. So relevance means that it's something that's important to or makes more likely to be true a fact.
Okay, I'll stick just to today then. I feel, and when we go to a final hearing, I could provide plenty of evidence of the kids happy, healthy, and wanting to spend time with Tara before and after any allegations were made, even to the most recent month of February. DCS, I had regular contact with DCS. I never dodged a phone call, never dodged a text. If anything, I was the one that was pursuing information from DCS to try to ensure that everything was going streamlined so we could get some normalcy at the house, because allegations of any type of abuse is obviously serious and is not in the norm for a normal household. Myself, I fortunately was able to establish a late night phone call randomly on a Saturday night from the person that administers the first evaluation and assessment. And she was able to get me in really, really quick. Tara's was not able to be scheduled until I think it was 2 months prior to them assigning that to them people. Tara Morsillo made multiple attempts to try to get it moved along faster since Madison kept asking us, when are we gonna get them done? Do you know when the schedule is? We were open to DCS on the first day. She asked to visit. We made ourselves available, even though Tara was working. She stopped work to accommodate time for Madison. Madison found no threats in the house. The only pictures she showed us of child abuse were brown marks on Lionel's thigh, and she said it was bruising from pinching, the allegations. I made a statement to her that brown bruising is not a couple days old or even a week old. I'm not a medical doctor, but I can tell you brown bruises, just from growing up the last 44 years, is usually over a week old bruises. She said that after that allegation, there was more allegations, and that she was needing to follow up. She was trying to close it, but she said with the outside source, she still had to investigate. So by that time, I believe I had finished all my assessments and evaluations. Tara did her evaluation, even though we did note with DCS that we're not sure if it was the right one. Madison explained that it was very frustrating trying to deal with the outside sources. There's proof that Tara, on the day that she was scheduled, did her assessment. There was no delay in it. Whenever I contacted Family Services, and I'm the one who reached out to Family Services, I talked to Dana, who was handling the case. She said that she would have to get back with me. She got back with me, and she explained that since we moved out of state, that the state would not pay for, or TennCare would not pay for the classes. I offered to pay the classes myself, but she said that she doesn't see a problem. Both her and Madison said that.
I'm going to object as to anything else they said, if it was recommendations, Judge.
All right, the objection is to hearsay, so I sustain the objection. Where did you move to in Florida?
I provided documentation the first time to 2060 Canopy Boulevard, DeLand, Florida.
Delaney, Florida?
DeLand, D-E-L-A-N-D.
Okay.
Sorry, my voice is a little scratchy.
All right. Why did you move to Florida?
There's multiple reasons. We kept on visiting my brother in South Florida, and he's the only family member that I have left. My past career and all my friends are in Florida, and whenever I was talking about moving back, I got multiple job opportunities to go back. One was going back to something I was kind of used to before I met Whitney, and the other one was more like a passion, but I would be able to have great opportunities in that. And it was not to dodge DCS because I complied before anything ever happened. And I mentioned it to DCS that we were planning on moving, and her recommendation was to, obviously moving out of state, I wouldn't be able to follow it all, but try to accommodate the schedule the best I can until there was a hearing on a revised parenting plan. Tara and I have always provided the kids with a happy, healthy home. They've always had their own room, which was which was in the parenting plan, which Whitney also failed to provide. And even when we relocated, we ensured that both children had their own room as well. To accommodate Lionel, I've reached out to multiple speech therapists, and if they aren't inclined to do it on the weeks that I would have the kids, then I would do virtual or get the worksheets for Lionel's speech therapy, which whenever I attend his speech therapy, I get the, usually it's just a piece of paper, but it's the words that he's practicing for that week or for that month. And during the summer is usually whenever I'm able to take him to his speech therapy, because usually it's during the week and I don't have them during the week. And the only time I've ever altered any of my parenting plan prior to the move was Lionel was having difficulty with me handing him off to his mother, which is documented on video as well. He did not want to go to her, and to provide an agreement between both parties was to provide less handoffs, that I would switch from, instead of Thursday to Saturday, that I would switch from Friday to Monday. And the kids never struggled to wake up for that like hour earlier, because we were living in Franklin, so it was like a 50-minute drive to get to her school. The kids never struggled with that. Lionel has always been provided ample time for his speech therapy when he's with me. The speech therapist explained to me that he was not getting practice at home, and that's wherever I first.
I object to that, Judge.
Okay.
It would be hearsay, sustain the objection.
So when Lionel is with me, I do go over speech therapy with him. I've explained that to Miss Morcillo, Whitney Morcillo, and she does not like that I practice, and she asked me to basically not acknowledge any of his speech impediments, that it would make him self-conscious. Other than that, DCS and Family Services never saw a viable threat in my household, even with, I'm not sure what was ever given to them. I've never got documentation from DCS or Family Services, but up until February, the end of February, they never once intervened with my time with the kids, and the documentation with them was there was no threat.
Well, you knew what your parenting plan provided for you in the way of visitation with your child, children, and you knew that before you moved, correct?
Correct, I knew that.
What did you envision was going to happen if you moved all the way to Florida and you had that type of visitation?
I had hoped that Whitney and I could co-parent and figure out what was best for the kids.
Because what would that be? I'm asking you, what did you envision would happen?
Originally, it's hard to say it if I can't mention the offer before the lawyers were involved.
No, I'm asking you what you envisioned.
So I envisioned, like what was mentioned before, less frequency, so less handoffs with the children, and I would be able to, since it would be prolonged periods other than the 2-3-day overnights, that I would have better quality time with the kids.
And how old are your children?
Emerson is 11 and Lionel is 4.
So your oldest is in school.
Yes, sir.
And during a school year, what did you envision would happen as far as your visits with her?
My recommendation, I'm confused on answering that, but I guess you'll stop me if I'm saying anything wrong. My time that I recommended did not interfere with the children's school. It was an alternating spring break, since it's only 1 week. It was 1 week for fall break, since there's 2 weeks. 1 week for winter break or Christmas break, because it's 2 weeks. And then the only thing we weren't able to decide prior to mediation was the length of the summers. And she recommended 1, and I wanted more than just 1 week. And the only thing we did different was, instead of me doing a week where the children were dropped off on like Sunday and then school starts Monday, that we would give them time between so that they would be able to adjust back to the schedule. And that was about as far as we got before lawyers.
So your vision was that when you moved to Florida, you were not going to see the children as frequently, but you were saying that you would have longer periods of time.
A better quality of time with them. Yes, sir.
All right. Anything else you want to say before we move forward? Ms. Duke is going to be able to ask you some questions.
I wish that Wade and I could be better co-parents.
What?
I just wish that the two of us could be better co-parents.
Okay.
You stated just a minute ago that Emerson is 11, but do you know she's 10 years
10,
old?
10, sorry.
Okay. And you stated that you moved to Florida to be closer to your brother, but you moved to Central Florida, which is about 6 hours from South Florida. Is that right?
It's not that far.
It's a significant distance, though, isn't it?
For the way I drive and travel, that would not be significant for me. A 4-hour drive or 3.5-hour drive is not a lot.
And sir, you said you moved there for job opportunities, but you're actually working at a fish aquarium store right now. Is that right?
That was one of the opportunities I mentioned before.
And you're making minimum wage there?
No, sir.
Okay. What, are you making more than you were making when you were working in Tennessee?
Before I left Tennessee, I was not working, so it is more. But it's not more than whenever I left Specialty Electric.
Because, sir, you were trying to get away. It wasn't that you had a better opportunity, because you didn't have a better opportunity at a fish aquarium store in Florida, did you?
Yes, because it's a passion of mine, ma'am.
Okay.
Miss Duke.
How much are you making there?
I make $17.50 starting off for the first month.
And how much did you make at Specialty Electric when you were here?
23.
Okay. And so you've gotten a better job opportunity in Florida?
Yes, ma'am.
That's your statement to this court?
Yes, sir.
I'm sorry, how much do you make in Florida?
$17.50 at the current moment.
He was making 23 at Specialty. And you're so involved with speech therapy here, right?
Sorry. Speech therapy is usually during Miss Morsillo's time. That's where she scheduled it.
Okay, but you said that you've worked with the child, you've done all this with speech therapy.
Yes, she even asked if I could provide documents to her that were given to me by the speech therapist.
Okay, what's the speech therapist's name?
It changes every few months.
Give me one of them.
I can't recall at the current moment.
Give me one name out of the 4 or 5 that this child's seen.
I can't recall. I've
Because
only
you've
met
not
them.
been involved, have you?
I have been involved with his speech therapy, ma'am.
And then you said earlier that you've not forfeited any of your time, but you have in fact forfeited your every other Thursday to Friday, haven't you?
Yes, whenever we made an agreement that we would do the schedule that we both agreed upon.
So you forfeited that time, and then you just up and moved, and since February the 20th, aside from Miss Morsillo making sure you saw them when you were in town, you've not seen your children.
I asked to see the kids. She did not offer the time. She agreed to the time, but she did not offer the time.
But she made sure to deliver them to you and pick them back up, right?
Yes, ma'am.
Okay. Does she get any credit for that today?
Absolutely. She could have declined it.
Judge, that's all.
All right, thank you, sir. Step down. Do you have any other witnesses? Ms. Duke, do you have any rebuttal? And I'll hear you in argument.
Briefly, Judge, the father moved without permission of this court, and the father did not have good reason to relocate to Florida. He said he had better job opportunities, which is not accurate. He said he was moving to be closer to family, but I'd submit to the court that 3 to 4 hours away from family is not enough. The father has slowly forfeited parenting time through today's date. And I do not think at this point in time that it is in the best interest of the minor children and could potentially cause some irreparable harm for the minor children if the father continued to exercise the schedule which is currently in place. I would ask that pending a final hearing, that all visitation occur in Tennessee. While the father wants to purport that he's a good father, I mean, he couldn't even name one of the 4 or 5 speech therapists that the kids have seen. And he couldn't even tell you what the child's age is. So at this point in time, I just ask that the court limit all visitation to be in Tennessee, and that it be on maybe an every other weekend schedule or something like that. The mother's not opposed to it being the same schedule, provided that it's in Tennessee away from the stepmother.
Mr. Marcello, do you have anything else you want to say?
I apologize for saying that Emerson was 11. It's just obviously
That's
representing
not a big
myself is
deal.
nerve-wracking, and it was because of the prior case that was in here because their daughter was 11. It just came out 11. I am not a threat to the children. They will say I'm a threat to the children, but they constantly will tell you that whenever Tara's not around, there's never any problems. They'll claim that I've given up time, but at the same time, Ms. Morsillo has asked me to take the kids on multiple occasions, and even to the point where I had to bring babysitters to my house that I did not know just so she could go to work. But yet I'm a bad parent, which is not the case. The fact is that the kids do want to see me. The fact is that the kids do want to see Tara. Tara just told Whitney to get out of her car. And from there on, that point, that weekend is when the allegations have started. She's blacklisted like anyone else who's been any friction against Whitney.
You are testifying rather than just giving me your final statements.
Yeah. The fact is that DCS, Nor Family Services, who both had my phone number, both had my email, both were provided addresses along with Whitney and her lawyer prior to the 30 days, and a physical address at that fact, 2060 Canopy Boulevard, or Canopy Terrace Boulevard, DeLand, Florida, was required. When I consulted a lawyer, I was told I was allowed to move, and I've interpreted that the documentation that I got didn't have a judge's signature on it. So I assumed that I was able to move since Ms. Morsillo or Whitney Morsillo offered a schedule that was out of state. When it comes to the job opportunity, I understand that it's $17.50 an hour. But just like whenever other people pursue certain paths, the pay obviously starts off low. Just as Ms. Morsillo pursued English as a passion, I pursued a passion that would make me happy and long-term would give me stability. I have never missed child support. Every tax year, I was able to claim Emerson due to the fact that I've always been caught up on child support. I don't dodge it. There's a couple of times where it's been behind by a few days, but that's something that I cannot do or I cannot help because I go through the Tennessee website to provide that. Even whenever times I was unemployed, she still got her child support, and I just used my savings to pay child support. I've offered multiple times to take the kids as well. That wasn't my scheduled time. So it's not like I'm trying to dodge time with the kids because I do love my kids. There's a reason I adopted Emerson. There's a reason why I cherish Lionel. They're my kids. I protect them. They've never been in harm's way. If there was ever any harm to my kids, it would be taken out of the equation. I would not ever put my kids in harm's way. Whether it be a wife, a brother, a friend, a stranger, it would be the same result. It would be taken away from that situation. And that's all I have, Your Honor.
Thank you. This is here today solely on the motion to suspend the visitation that was set forth in the final decree of divorce and the parenting plan that was adopted and agreed upon by the parties at the time of their divorce, pending a final hearing. And the court finds that by the admission of both parties, both Ms. Marcellus and Mr. Marcello, both of them agree that the prior plan is not workable on a temporary basis And for that reason, the court grants the motion to suspend the court-ordered visitation set forth in the parenting plan pending the final hearing. Now, then the issue becomes what schedule shall Mr. Marcello have with the children, and how much time should he have, and where should he exercise that time, and under what circumstances? The problem that we've got in this situation is that you have one view of parenting, and your view of parenting is that it's okay to give up the weekly contact with your children, one of whom is fairly young, and move hours away, and then without permission from the court, and then instead of having that regular visitation on a weekly basis where you saw your kids every week, you're then going to have extended periods further apart. And I understand that when you calculate the number of days, that may be in your mind the same amount of time. But for young children, this court is of the opinion that the frequency of visitation especially is more important than oftentimes the length of visitation. There is enough evidence in this record to indicate to the court that where DCS was investigating this case and was making recommendations for you and your wife, and apparently you followed all of the recommendations, but your wife had not completed everything one way or the other, then your wife had not basically fulfilled it before you moved. There is an inference there that the reason for your move may have been more related to getting away from the Department of Children's Services investigation than your professed desire to be closer to your brother, who is still many hours away from you or several hours away from you. I'm of the opinion that on a temporary basis, the schedule that Mr. Marcello shall have shall be 1 weekend per month from Friday until Sunday, Friday at 6 to Sunday at 6 in the state of Tennessee. He can exercise that in Dickson County or Davidson County or any of the surrounding contiguous counties if he wishes to do so. Pending a further hearing before the court, and I don't have Mrs. Tara Marcello before me for me to make any determination about her character or her trustworthiness, then I cannot, and in view of the Department of Children's Services recommendations not allegedly having been fulfilled, then I must, at this point, order that she's not to have any contact until a further hearing before the court, in which time this court will consider whether or not she has completed any of the things that the department wishes or wanted her to do. I'm not saying your wife abused the children, but that was the allegation that was made, and until the allegation can be fully investigated and all of the recommendations followed, it is my belief that the children's best interest requires me to protect them against any potential. I don't know your wife, and as a result of that, I'm not trying to make any false accusations about her, but I can guarantee you that there are plenty of situations where one spouse or one partner thinks that their partner is a good parent and a good caregiver to their children, only to later find, unfortunately, that that was not the case. I've got a case over in Dickson or in Cheatham County where a father allowed his girlfriend to provide care for his, I think it was 6-year-old son. And he thought everything was fine, that she was taking good care of him. She beat that child every day of that child's life for months until the child died. And fortunately for the world to know, that was captured, a lot of it was captured on video because she took the child to work with her. And as a result of that, father supposedly thought that she was doing a good job of caring for the child. My point in making that is not to say that that's a direct correlation to your situation, but it's to give you an illustration of why, after all of these years of doing what I do, that I'm going to err on the side of protecting children, even if it is an inconvenience or a problem for the parents, because the children didn't ask to be put in this situation. So my ruling is on a temporary basis, it's 1 weekend per month. I would like to see Mr. Marcello have some extended time with the children. But as quickly as we can do, we're at the beginning of the summer. I would think before the end of the summer, there should be enough evidence about Mrs. Marcello that would allow us to consider giving him an extended period of time in Florida with the children rather. So I just think if you talk to Ms. Duke and find out what they're needing to satisfy them, then whatever you two can agree upon, it would be fine with me. But I do envision that it would be good for the children to be able to go see their father for an extended period of time in the state of Florida once he's established and has everything set up.
One question I have for your honor is, based on the fact that it would be a new place for the kiddos, would it be possible to have a short visit? Like when we're coordinating, it makes more sense to have a little short visit, mom be down there, and then maybe extended if it's going well.
Turn his microphone on. There's a microphone in front of you. Turn it on.
To answer your question, one of the recommendations that I was giving, and I'm pretty sure I provided it to Whitney as well, was that we had agreed upon spring break for the most part, winter break and winter break and fall break.
We can talk about this from here.
But,
I was just looking for direction.
Yeah, but I did recommend that it started off slow and each year it would increase.
And I think that's a reasonable position to take. What I'm saying is right now, your visitation is going to be one weekend per month in Dickson or Davidson County, one of those contiguous counties. But it should be possible for you two to work out an extended period where maybe a weekend occurs in Florida rather than, you having to come up here, then she can bring the kids down or y'all can meet somewhere or something on that order. But I would like to see them get acclimated to your new home. You're a father. You have the right to have your children with you. I may not agree with your decision-making, and the fact that you moved without getting prior approval of the court is part of the problem that you're facing right now, because once you submit yourself to a court because you two can't agree and the court has to put an order down in a parenting plan, you're bound by that order and parenting plan. And that parenting plan requires you to file the notice. And if you don't get an agreement, you have to file something in court and get an approval of the court before you move. And you didn't do that. So that's the reason that you're suffering now with only having to come up here during the time. So,
Judge, are you giving us a little bit of purview on the visits here? If part of the DCS requirement was for them to be able to lay eyes on Tara interacting with the children. So as long as mom approves of it to get that portion of it completed, the no contact, if
my no contact is because there was not a completion of the Department of Children's recommendations and there was some concern. I have no reason to believe that Ms. Tara poses any danger to these children, but that's the problem with being a step-parent. When you're interacting with children that are not your own and you're bathing them or dressing them or doing whatever, and you accidentally pinch one of them or you accidentally do something, it can be misinterpreted. Can be a difficult situation. So I think as long as Ms. Whitney Marcello is satisfied that Ms. Tara has met whatever conditions are, and then you two can agree on it, then that will be fine to put an order down that suspends or does away with my no contact order. So my no contact order for Tara is only until there's been some inclination or some completion of what the Department of Children's Services had in mind during their investigation. And put that language in the order.
I'll be happy to.
All right. All right, anything else?
Nothing else.
When it comes to the recommendations of, I guess it would be family services or back to DCS, but they both, one shifted the case over to, or DCS shifted it over to family services and family services closed it. Is the proof that you guys needed something that's automatically given to you guys, or is it just provided to us?
You need to talk to Ms. Duke because there's.
We'll just have to coordinate getting the case opened back up to do what we got to do. Not
All right,
Thank you, Judge.
we are adjourned.